to Mr. Clements. I'm not sure he's
Ms.
in
Farkas,
custody.
do you need to go in a breakout room?
Do you need a breakout room with your client before we call the case?
Are you talking to me, Tammy?
Yes.
No.
Okay.
Thank you.
Okay. We'll call it first and then I'll call yours. Calling parties on Clement. Case number 2062764. The people of the state of Michigan versus James Andrew Clement. The defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. Count 2, motor vehicle unlawful driving away. Count 3, stolen property, receiving and concealing $1,000 or but less than $20,000. Habitual offender, second offense notice. We're here today for a competency hearing.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Slosky on behalf of the people, P83677.
And good morning, Your Honor. Neighborhood Defender Service by Stephanie Farkas, P74227, appearing on behalf of Mr. Clement, who's present via Zoom from the jail.
Thank you. Mr. Clement, can you please state your name, sir?
James Andrew Clement.
Thank you. I have a report back. Does the prosecution and defense also have a report?
Yes, Judge.
I believe so, Your Honor.
Okay, and what is your posture at this time?
Judge, the finding from the Forensic Center is that Mr. Clement is competent to go forward, and then they also did criminal responsibility, and they found that he was still criminally responsible. So at this time, Your Honor, we're asking to proceed to exam now that Mr. Clement has been medicated. That was the main reason that I think that he was not competent when that I suspected he wasn't competent.
Are you going to stipulate to the findings of the evaluation?
Yes, Judge.
Mr. Prosecutor?
Same, Your Honor. I believe we're ready to schedule an exam.
Pardon? Wait, say again?
Can you hear me now? Is this good?
I heard you, but the last part, I just want to make sure that we're getting your words. I didn't hear what the last part was.
Understood.
Okay, are both parties stipulating to the findings of the evaluation, yes or no?
Yes.
Yes.
Okay, the court does find the defendant competent to stand trial. The next step would be to provide an examination date. The defendant is in custody, so I would like to set this as soon as possible. Do we have an opening the week of the 26th of July? I know we don't, but can we create one?
I'm looking. Oh.
And Judge, I am going to be going to the supervisor at the prosecutor's office in hopes of potentially trying to resolve this short of a prelim.
Okay,
And if we are able to do that, I will contact the court.
that would be great. Thank you.
26 at 11 a.m.
That works.
I do have another exam scheduled at that same. Actually, I have 2 exams on the 26th scheduled for 11. Could we do at 10:30 perhaps?
Sure.
Okay. July 26th at 10:30, in-person examination, unless we hear otherwise that there has been some resolution that defense would like to take advantage of. So we will see you then. Is there anything further?
Not from the people.
No, Judge, thank you.
Thank you so much.
Division 1, what's your name, sir? All right, I'm going to call your case. Calling parties on Chavez. Case number 2156140. The people of the state of Michigan versus Mauricio Chavez. The defendant is charged with count 1, motor vehicle unlawful driving away. Count 2, larceny in a building. Count 3, domestic violence. Judge, this is scheduled for an exam on Monday, but defense counsel has scheduled a motion to adjourn.
Okay, thank you. Appearances, please.
Mr. Bloomers.
Mr. Bloomers?
Mr. Bloomers?
Officer, it's cooler.
I'm here. I'm here.
Okay, I called the Chavez
It's
matter.
not warm.
Okay. Jacob Peters, P77307, half of the people.
Okay,
Good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services, Ken Riggins, P82125, on behalf of Mr. Mauricio Chavez.
okay, good morning, and Mr. Mauricio Chavez, is he present?
He's not present, actually, we waived his presence for this proceeding.
So ordered. So this is being called in advance of the scheduled examination date of July 12th
Yes, Your
for
Honor.
the need to adjourn.
Yes, Your Honor. A few weeks ago, we came here, I requested a Spanish-speaking interpreter. Mr. Chavez speaks little to no English whatsoever. I was able to finally reach the Spanish interpreter, but we first touched base Tuesday of this week. Since then, I've had two 40-minute Zoom meetings with both the Spanish interpreter and Mr. Chavez. After the first one, things are moving very, very slow because everything has to be interpreted. After the first meeting, I realized that there was no way that we could be prepared trying to fit around everyone's schedule in time for a Monday preliminary examination. So I contacted Mr. Bloomer, asked him would he stipulate to an adjournment. When he said he would stipulate, I filed a motion to ask for our adjournment. I believe that if we are giving approximately 2 weeks or whatever the court thinks is reasonable, I believe we can be prepared for preliminary examination.
Perfect, so there's no objection from the prosecution.
No, Your Honor, I think there's good cause here.
Certainly, I would agree, and we're gonna select a new date. Today's the 9th. I think it's probably safest to look, Madam Clerk, the week of August 2nd or the week of August 9th. This is a non-custodial situation. However, given the fact that it is domestic, I do want to keep it close as possible, but that week of the 26th is so jammed. So anything the week after or the week after that.
August 5th at 10 a.m.
Do you have anything later? I have the 5 matter already scheduled in front of Judge Jefferson.
Can you do August 6th at 11 a.m.?
August 6th, I'm free, yes.
And how many interpreters are needed?
We will need one for the complaining witness as well.
I believe she is also Spanish.
So 2?
Yes.
Okay. And I can cancel the one for Monday, correct?
Yes.
Okay.
Okay, perfect. The new in-person examination date, August 6th at 11 a.m. And I've made a notation, as has Madam Clerk, that 2 interpreters will be needed. And we will see everyone then.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
I'll give you a copy of that, sir, just a second. Do I have the parties on Holloman?
Ready.
Case number 2057643, the people of the state of Michigan versus John Antoine Holloman. The defendant is charged with count 1, police officer, fleeing third-degree vehicle code. Count 2 and 3, assault with a dangerous weapon, felonious assault, habitual offender, fourth offense notice, commission of a felony with a motor vehicle advisory, Judge is scheduled for an exam on Monday, but they would like to enter into a waiver today.
Thank you. Appearances, please.
Good morning, Your Honor. Remax with BP 82800 on behalf of the people.
May it please the court, Your Honor, Michael Sharp, P 37633, on behalf of Mr. Holloman, who's here on the Zoom.
Thank you. Please state your name.
John Holloman, Your Honor.
Thank you so much. Okay, counsel?
Yes, Your Honor. I've gone over Mr. Holloman's statutory rights. He understands, and quite frankly, I feel that he is appreciative of those rights. That being set aside, he would like to bind the matter over or waive his examination and be bound over to the circuit court.
Okay, is there any objection to the proposed waiver?
No objection, Your Honor.
All right. Mr. Holloman, do you understand the allegations against you, sir?
Yes, Your Honor.
Do you understand that you have a right to a preliminary examination?
Yes, Your Honor.
Do you understand that if an examination did occur, that the prosecution would need to establish by a probable cause standard that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes?
Yes, Your Honor.
If the prosecution were able to meet that burden, the matter would then be bound over to the circuit court for further proceedings. Do you understand that process?
Yes, Your Honor.
Thank you. So the representation has been made that you wish to waive, to give up your right to a preliminary examination. Is that true?
Yes, Your Honor.
And do you understand that that means that this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an examination at this phase?
Yes, Your Honor.
And is that still what you wish to do?
Yes, Your Honor.
And are you doing so voluntarily, sir?
Yes, Your Honor.
Thank you. With that being said, and I do have the examination waiver form that has been returned to the file and properly executed, I do find your waiver to be knowingly and voluntarily. The matter is now bound over to the circuit court for further proceedings with an AOI date of July 30th at 9 a.m. Is there anything further?
No, Your Honor.
Thank you so much. You can log
Thank
off
you.
now, sir.
Thank
Okay.
you.
Hey, what do you need? Yes. Yeah, it was just removed from today. That was the date that the magistrate said, and when the new date was entered, it wasn't taken out. I took it out today, so he just needs to go back. There's nothing scheduled for him today. Yes. Okay. Yeah. Judge Archer's going to him. What is the case that she's a witness on? I don't have a Terry, Judge Archer doesn't have a Terry on the docket. Is she a complaining witness on a case?
Good morning, Ms. Michon.
Did we need to be called? Clements?
Good morning.
No,
Okay,
that
I'm
one
trying to see.
set.
Division 1, what is your name, sir? Yeah. All right, it's,
Yeah, Tammy, I'm afraid I can't be much help. I haven't had the opportunity to meet Troy.
oh, so you don't know. Yeah, I don't know.
I
who
do
that-
not. We got the assignment on literally on Tuesday.
Looking for someone. So as soon as someone comes in, we'll call it. Do
No
I have
worries.
parties on Young?
Ready, Tammy.
Case number 2060711, the people of the state of Michigan versus Daniel Garcia Young. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony firearm. Judge, this is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Yakub on behalf of the people.
And good morning, Your Honor. May it please the court, Leanna Belcher, P80177 on behalf of Mr. Young. Unfortunately, Your Honor, Mr. Young is not present today. I've been informed by the family yesterday that he is in the Oakland County Jail. I did confirm that on the Oakland County Jail website. I also looked up his case in Oakland County. He has a pending matter that's set for an arraignment on July 16th. So, Your Honor, we would just need a new exam date so that we are able to get Mr. Young here from the Oakland County Jail.
Okay, so with that being said, he will be considered in custody. You said that his arraignment is July 16th.
That is correct.
I think, pardon?
Yes, Your Honor, I said that is correct.
Thank you. The week of August 2nd?
Yeah, that's what I'm checking. August 2nd at 10:30.
Would it be possible at all to have any later in the day? I'm scheduled until 11:30 in Romulus.
We'll just pick a new day. I mean,
I'm sorry, Tammy. I have the morning of the 5th completely open.
let's do that. I mean, we really don't have a day anyway, so we're just making room for it.
I'm sorry.
No, that's not your fault.
Okay, so
Can you do the 5th at 10 a.m.?
Yeah, that works.
Okay.
Okay, in-person examination, August 5th at 10 a.m. And just for the sake of the record, are you asking to waive your client's presence here today for scheduling purposes?
Yes, Your Honor, I would ask the court to waive his appearance.
Thank you. And you indicated he's in Oakland, correct? Oakland
Yes.
County?
Yes, Oakland County.
He will need to be writted for this in-person examination. And is there anything further?
Not from the defense, Your Honor. Thank you.
Thank you.
Have a good weekend, everyone.
Thank you.
Do I have the parties on Darby?
Two.
Hello.
Calling case number 2056067, the people of the state of Michigan versus Franchelle Dion Darby. The defendant is charged with count 1, lawful imprisonment, SORA notice. Count 2, weapons, firearms, possession by felon. Count 3, assault with a dangerous weapon, felonious assault. Count 4, 5, and 6, weapons, felony firearm. Count 7, domestic violence, habitual offender, fourth offense notice. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Your Honor, Harry Mihas, P number 66417 on behalf of Mr. Darby.
Good morning. And your client?
I do not see him. We talked to him yesterday. He's well aware of today's hearing.
Do you have a case number?
Are you asking the court to waive his presence, or did you want to wait?
I'm okay with waiving his presence, Your Honor.
Okay, I will waive his presence for purposes of today's PCC.
I need you to speak up for swearing session.
It looks like we have,
I need you to talk.
oh no, we do not. So what's your pleasure
Just give
today?
me one of them.
Your Honor, my hands are somewhat tied. As I mentioned before, the Honorable David Braxton in the Third Circuit Probate Court ordered
What?
psychological evaluation, medication, and hospitalization. I do not believe that my client has conformed with that. The implications of that are that he may not be competent to stand trial or to proceed right now. So as an ethical matter, I have to raise that with the court. But I've had no indication that Mr. Darby has acted on Judge Braxton's order.
So what would you like to do, sir?
Okay. Well, the court opens it.
So what would you like to do, sir?
When we adjourn the PCC for several weeks, I will be out of town. I will be in Greece for the next 10 days.
Oh,
I have
nice.
to quarantine for a week, so it will be nice. It will be nice.
That sounds lovely. Right about now. Okay, so I can't get past Greece. What are we doing here? We're setting this for a few weeks out. Today's the 9th. What about the week? What about a new PCC on the week of, how about August 9th?
August 9th. Yes, we can do that. Thank you, Your Honor.
You're welcome. And hopefully we'll have a better understanding of the trajectory of where we're going with this at that time.
And do 8:30 again?
Yes, 8:30 via Zoom, new PCC. Any issues with discovery?
We will try and clear up whatever's going on, Your Honor. Thank you.
I didn't understand what he said. Were there any issues with discovery, sir?
No, we have full discovery. We just don't necessarily have a client right now. So,
Yes, I understand. We need him. Okay, we'll see you then. Hopefully with your client on Zoom gallery as well.
yes, Your Honor. Thank you.
Deputy Division 1, who do we have there?
Good morning.
My name is Troy Poppert.
Miss Michonne, did you need a breakout room?
That
Yeah.
would be lovely, please.
With, Wayne County Division 1. WCSO. Do I have the parties on Smith, Paul Smith?
Yes, I'm here. Defense counsel is here. Ms. Brookins was present. She's on the, I believe she's on the Zoom.
I'm waiting on her to sign on.
Okay.
I'm here. Sorry about that.
All right, that's okay. Calling parties on Smith, case number 2056257. The people of the state of Michigan versus Paul Ellis Smith. The defendant is charged with count 1, criminal sexual conduct, first degree, multiple variables, SORA notice, HIV, STD testing notice. Count 2, criminal sexual conduct, third degree, force or coercion, SORA notice, HIV, STD testing notice, habitual offender, fourth offense notice, judge scheduled for preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Natalie Brookins appearing on behalf of the people, P76349.
Good morning.
Good morning, John J. Holler appearing on behalf of Paul Ellis Smith, who is in the state prison system at Kincheloe. I don't believe that he's zoomed in with us.
Did you want, I don't know if he's been Zoom written for today's hearing here today. Did you want to wait for him?
No, I don't. I talked with him at really sufficient length personally on a confidential phone call within the last few days, and he understands the problem with hurry up and wait and things like that. And we had a substantive conversation. We had a procedural conversation. We talked about scheduling and everything else. So no, it's not necessary.
You're requesting his presence here today?
I'm requesting his presence be waived.
That, yes, that's what I said. So yes, so ordered. So what are we doing here today?
Your Honor, today we need an adjournment of the exam. The defense has requested that this exam be in person, and without being able to bring the defendant here, that cannot be accomplished at this point.
Do we have any idea of a time frame in which they will be doing a transport?
We do not know.
That's unfortunate. So what is?
It's incredibly frustrating.
Yeah, tell me exactly what you're asking for. I mean, I can arbitrarily just give a new date, but I don't. If you have more information about what might make sense, then I'm here for it.
Judge, I think 2 months would make sense. They need between 2 and 4 weeks to process the writ. So to give time for the situation to change, whatever holds up transportation, give that a month to see if it changes. Then I'll submit the writ and see if we can get him here in the following month.
Okay, first week of September? September? How many proposed or how many witnesses do you anticipate calling?
I anticipate calling 1 witness and presenting laboratory reports.
Okay.
September 8th at 11 a.m.
That works for the people.
That's fine for the defense.
Okay, new in-person examination, September 8th at 11 a.m. And hopefully there will be an actual transport at that time.
Thank you, Judge. And if there is not, I will do as I have before and reach out to the court to make sure we don't clog your docket unnecessarily.
Thank you, I appreciate that. Okay, we're all
Have a
set.
good
Thank
day.
you so much. You too.
Do I have parties on Harris, Devontae Harris?
Yes.
Is that your case, Ms. Upwood? Calling case number 2157774, the people of the state of Michigan versus Devontae Jermaine Harris. The defendant is charged with count 1, weapons, carry and concealed. Count 2, malicious destruction of fire or police property. Count 3, 4, and 5, police officer assaulting, resisting, obstructing. Count 6, 7, and 8, weapons, felony, firearm. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Kuki on behalf of the people. I think Ms. Wada is muted.
I'm sorry. Good morning, Your Honor. Coral Watt appearing on behalf of Mr. Harris, who I believe is present.
Morning. Okay, Mr. Harris, please state your name.
Devontae Harris.
Thank you. Counsel, what's your pleasure?
Your Honor, I do not have discovery in this case yet. And so I am requesting a PCC date and adjourn one so that I can.
Oh, no, you're open. You're open.
So that you can receive the discovery and review it with your client?
Yes, yes, Your Honor.
Okay, so with that being said, I do find good cause to grant a new PCC. That date will be August 6th.
Your Honor, I will be out of the country from August the 3rd. Well, you know what? I could get someone to stand in for me, Your Honor. I could do that because they would just be either waiving or setting an exam date. So if the court has to keep that date, I can make it work.
No, I'm flexible. Did you want to do August 15th?
August 15th would work, Your Honor. Thank you.
13th.
13th, yes, the 13th would work.
Okay, new PCC, I do find a good cause to grant that. It's going to be set for August 13th, that's a Friday, at 8:30 via Zoom. Mr. Harris, you would zoom in on that date just as you've done today.
Okay.
Thank you, Your Honor.
Dr. Lupi, can you make sure that she receives that discovery?
I'm gonna reshare it right now.
Okay, perfect. Okay, we're all set, thank you.
Thank you. Have a great weekend, everyone.
Okay.
All right. Do I have anyone else that needs to check in? And I see I can call Miss Michonne's case, so I'll do that. Calling parties on Popper, case number 2159182. The people of the state of Michigan versus Troy Anthony Poppert. The defendant is charged with count 1, criminal sexual conduct, 3rd degree force or coercion, SORA notice, HIV/STD testing notice. Count 2, criminal sexual conduct, 3rd degree force or coercion, SORA notice, HIV/STD testing notice. Second offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Judge, I think you're missing Mr. Bloomer on the matter.
He's walking over right now.
Oh, and is that his case or is that a special prosecutor?
I believe it is his case, that's what I have. It.
Okay, all right, yeah, I wish he would say, I'm on my way over, so I'll call it as soon as he comes back.
No worries. We will wait with bated breath.
Division 1, Floor 8, what's your name, sir?
That's Mr. Graham, and we also have Mr. Whitehead available. Would you like either one of those?
I'm Craig Tank. I'm present on behalf of Mr. Whitehead.
I'm gonna swap y'all out to those.
Christopher Quinn appearing on behalf of Mr. Graham.
Yep, I'm gonna call Mr. Graham because he's in front of the camera. Calling parties on Graham. Case number 2158852. The people of the state of Michigan versus Derek Keith Graham. The defendant is charged with count 1, criminal sexual conduct, 1st degree weapon use. SORA notice, HIV/STD testing notice. Count 2, criminal sexual conduct, 1st degree weapon use. SORA notice, HIV/STD testing notice. Count 3, unlawful imprisonment. SORA notice. Count 4, unlawful imprisonment. SORA notice. Count 5, 6, 7, and 8, robbery armed. Count 9, assault with a dangerous weapon, felonious assault. Habitual offender, 4th offense notice. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Judge. Christopher Quinn, P69483, appearing on behalf of Mr. Graham, who is appearing via video conference today.
Any idea who the prosecutor is? No one checked in, Judge.
Hi, Mr. Bloomer.
Good morning.
Can someone send an email to that division, please?
That one case back we tried to correct them all. This is a recall. Obviously, Mr. Quinn, I don't mean to leave you hanging. You know, we have to have a prosecutor, so we're gonna pass on that matter.
Can I get a breakout room? Can I get a breakout room, Mr. Graham?
Oh, yeah. Which one is he?
He was,
Recalling
Floor
people
8.
versus Troy Poppert,
Oh, they're both
P-A-U-P-E-R-T. This is 2159182. This case has already been formally called. They're both Floor 8. This case has already been formally called. Can I have appearances, please?
Jacob Bloomers on behalf of the people.
Sean go. Oh, no.
Well, never mind.
I always thought we were off. This is.
Mr. Quinn, I'm gonna put you in what I believe is a breakout room with your client. I'm not sure which one your client is. They're both 8th floor, so.
Oh.
Okay.
This is Mr. Graham, Miss Judge.
Okay. Thank you.
prosecutor in the system says, Miss Narcissian is,
Yeah, she's not in SAT anymore, so
yeah. I'm gonna have, if I ever get a spare moment and get some cell numbers. I guess we could switch out, Mr. Graham for Mr. Whitehead, because we do have the prosecutor and
I think
defense
Mr.
counsel.
Whitehead, I think they did swap. Is that Mr. Whitehead?
Oh, okay, I'll call that. Calling parties on Whitehead, case number 2159201. The people of the state of Michigan versus Jochuan Dion Whitehead. The defendant is charged with count 1, 2, 3, 4, 5, assault with intent to murder. Count 6, 7, 8, 9, and 10, weapons, felony, firearm. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Richard Nelson Jr. on behalf of the people, P78306.
My name is Craig Tang. Can I appear on behalf of Mr. Whitehead? My bar number is P58360.
Okay. If you could repeat what you just said, we couldn't hear you very
Craig Tank on
clearly.
behalf of Mr. Whitehead. My bar number is P58360.
Thank you. Mr. Whitehead, could you please state your name, sir?
J. Twan Whitehead.
Thank you. Okay, counsel, what's your pleasure?
Your Honor, we needed an exam date.
Would you like to pick a date the week of August 26th, or, I'm sorry, July 26th or August 2nd? We don't really have dates that are open, so you just have to kind of let me know what works for you and we'll try and muscle around it.
How many witnesses?
The week of July 22nd?
July 26th.
26th. How about the 28th?
How many proposed witnesses do you have?
3 or 4, Your Honor.
Do we have an afternoon?
We don't.
The first afternoon we have open is going to be in August.
How about the week of the 9th? Do you have anything then?
Check the 9th of August, yeah, I'm looking. Our afternoons are jammed up too. Didn't enter anything from yesterday yet, so.
Yeah, I'm not worried about that. I just want to get this, but I feel it's wrong.
You know, I think hearing actually is Mr. Quinn speaking to his client.
Oh,
I wonder if they're near each other.
I don't know.
That's not good.
I couldn't get everything entered yesterday, Judge, so I don't want to double book us on something and then we show up and we've got 4 afternoon cases scheduled.
Give us just a moment. We're trying to secure a date. Not very easy to do.
But I got all our, it seems like we did something on those dates.
I don't hear the echo anymore.
Yeah, so maybe they fixed it. Maybe she heard you. Just don't know.
Oh, I think what they did is they muted the chat.
I think the next available afternoon we have is the August 19th.
August 19th at 1:30.
Do you have your docket sheet from yesterday?
I'm not available that day.
Okay. Wait, Tammy, I know this sounds really bizarre, but for some reason, because you know my memory is not that good, I feel like we had an opening July 22nd at 1:30.
We already filled that in.
Oh,
Yeah, I'll double check it, but I'm pretty sure we filled that in. Yeah, with Levon dates.
okay. Oh, okay.
Morning, Judge.
Good morning, Mr. Nasser.
All right, let me go back to it.
Yesterday, the only thing you did was a sentence from Judge Brown.
Oh, okay, so no, okay, well, it doesn't matter, it was a good date for Monday. August 20th at 1:30.
Your Honor, I just so we're clear here, I have a prepaid vacation from the 16th to the 22nd.
I talked to that person. So he's on vacation.
He's on vacation.
Okay, so,
What was the time frame you're on vacation that we should,
From the
avoid?
from the 16th to the 22nd.
16th to the 22nd, so there was no afternoon.
the 23rd?
That's fine.
That works for the people, Your Honor.
Did have an afternoon the week of the 9th.
No, we're booked up. I'm looking
August 23rd at 1:30. In-person examination. Tammy, I think we need to set a second date. I just have a feeling. Can we set the 24th at 1:32 in case we need it?
Not the 24th.
Not the 24th? Because, I don't know, I mean, if it's gonna be 4 witnesses,
We can do the 27th at 1:30.
are you available on the 27th as a carryover day if it's necessary? As opposed to getting there and needing one and then not being able to find a date?
I am.
I am as well, Your Honor.
All right, so if needed, as a precaution, if it's necessary, we'll also set aside August 27th at 1:30. If it's not needed, then great, but if so, we've got that safety measure built in. And is there anything further? Do you have a discovery, Mr. Tank?
I do.
Okay, all right. Anything further?
I have nothing.
No, Your Honor.
Okay, thank you so much.
Ms. Michon?
Can I go to the break room with my lawyer or something?
Oh, he just left. If you get it, oh, well, they're getting ready to swap him out, so.
Yeah.
I'm assuming, Mr. Whitehead, he'll be contacting you, okay?
So my court date is when, ma'am?
August 23rd at 1:30 in person here in the courtroom.
Okay, thank you.
You're welcome.
Recalling Poppert. Case number 2159182. This case was previously called in full. It is scheduled for a probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of people.
And good morning, Your Honor. May it please the court, Kim Michon, Neighborhood Defender Services, P59167, on behalf of the defendant who is appearing from the Wayne County Jail via Zoom, and we do consent to do so.
Thank you. Please state your name, sir.
I don't think anybody's there to assist the gentleman, Your Honor, but I can inform you that that is my client.
I see.
Aha, maybe. Yay.
Hi, Your Honor. My name is Troy Anthony Paupert.
Thank you. All right. Today being a PCC, Ms. Michon, what's your pleasure?
Your Honor, as of this morning, Mr. Bloomer did provide us with discovery in the matter. I just need to know if there are any outstanding labs or medicals that we're missing. I haven't had a chance to download it yet.
I haven't so I will have to follow up with the OIC about that.
Understood, Your Honor. With that, though, we would be asking for an in-person preliminary examination, please, at the soonest possible date, realizing we're asking you to move heaven and earth.
Yes. Your client, however, is in custody, so that is giving him a level of priority over other non-custodial matters. So we're going to set this. Can we find the date first week in August?
How many witnesses, Mr.
Just the one, Your Honor, just the one.
And Madam Clerk, this is Jeff Kanucky's case from NDS. He has the audacity to take a vacation this week for the first time in a year and a half. He is completely open on the 2nd and the 5th if the court finds wriggle room on either of those dates. That would be best for him.
Thank you.
On the 5th at 10:30, August 5th at 10:30.
That's just fine.
Okay, in-person examination, August 5th at 10:30. We will see Mr. Konecki and his client, Mr. Popper, on that date.
One other matter, Your Honor, if I may we address the young man's bond?
Sure. His bond is currently $50,000 with a 10% provision. And obviously, a no contact provision. There's also a tether requirement provided he makes bond.
That is accurate, Your Honor. Just so the court is aware, he did attend high school and then after that went to trade school for brick masonry. He is currently employed with security as a security guard for the last year and a half. He would be residing with his mother, who is in Roseville, quite a distance from the complaining witness, who he previously, at the time of the alleged offense, resided with. He has no problems abiding by the bond condition for a no contact provision and has no issue with the tether requirement. We would be asking the court to consider a $25,000 10% bond.
Mr. Blumers.
Your Honor, these are 2 counts of criminal sexual conduct, 3rd-degree force or coercion. I think given the nature of the incident and the need to protect the community and ensure that the defendant shows up to his court dates, I would have to object to any modification of bond at this time. I think the current bond of $50,000, 10% for the GPS tether is reasonable. I don't think there was any abuse of discretion there. So I'm going to object to any modification of the bond given the serious nature of the charges.
May I respond briefly, Judge?
Yes.
Only to indicate to the court, and I do apologize, we are at a bit of disadvantage as we were just provided the discovery in the matter, but I heard Mr. Bloomer indicate that there may be some danger to the community. If this were in fact a criminal sexual conduct of a stranger situation, if having practiced criminal law for 23 years, we both recognize that some of these situations, people know each other and others they do not. I would be in agreement with Mr. Bloomers if they did not know one another. However, in this particular situation,
but they know each other. He's not a danger to
no,
the
but he's.
safety
I
of the
think
community with these allegations.
I think the issue is whether or not the rest of the community is in danger, and I don't think that to be the case. I think in terms of protection for the complaining witness, the no contact provision and the GPS tether would keep him at bay, along with his word that he will be residing with his mother, along with obviously the bond.
I respectfully disagree if that is the theory upon which you're approaching it. The allegations, I've had a chance to review it briefly, and I have to if we're discussing bond. And the two important aspects to consider, well, first thing is whether or not there's been an abuse of discretion by the arraigning magistrate, which I don't see in this case. But even if I were to push past that question, whether or not the defendant will return, I don't have anything that's standing out before me that's causing a red flag in that regard. So it does, although he is listed as, is he? He is, there is a second offense notice here. But the real concern for me is the safety of the community, which includes the complaining witness. And to me, I don't find that there's not an automatic conclusion in my head that perhaps he does not pose a safety concern to the public because he may have known this individual. The allegations are extremely serious. So the court does not find that there was any abuse of discretion in setting the bond at $50,000, 10%. In fact, it could have been higher. I think
I appreciate the court. Would you be amenable to a DSU report to readdress it if we hold the examination judge?
Yes, absolutely. I will make a referral for DSU. And keep in mind, even though you are now in custody and you make bond, or even if you don't make bond, you are to have no contact with the complaining witness, Mr. Poppert. That means not directly, but it also means not indirectly. No texting, chatting, no telephoning, no form of social media outreach, nor can you have anyone act on your behalf to talk, to communicate with the complaining witness. Sometimes that trips people up and they feel as though, well, that's not really contact. It is. So please make sure that you're abiding by those provisions that are put in place, and we are all set here.
Thank you so very much, Judge, for hearing us out. Have a lovely day to you and your staff.
Thank you.
You too. Thank you.
Are we ready to call Brown, Jamar Brown?
Yes.
Case number 2061517, the people of the state of Michigan versus Jamar Richard Brown. The defendant is charged with count 1, reckless driving causing death, count 2, reckless driving causing serious impairment of a body function, count 3, operating while intoxicated causing death, count 4, operating while intoxicated causing serious injury, count 5, operating license suspended, revoked, denied causing death, count 6, operating license suspended, revoked, denied causing serious injury, habitual offender, third offense notice, commission of a felony with a motor vehicle advisory. This is scheduled for a preliminary exam.
Tammy, what's going on with Jamal Urban?
He's in custody. I haven't, no one has checked in on it yet, Judge. Is Mr. Carlissimo in the hallway? The defense counsel?
He checked in earlier.
He is here? Okay.
Can I trouble you for having him come in, because that's an in custody matter and it needs to be addressed, or else we're gonna have an issue. Was Urban transport?
He's here, he's downstairs, Judge.
Yeah.
Okay, appearances, please.
Good morning, Your Honor. Jonathan Mysek, P74620 on behalf of the people.
Good morning, Your Honor. Trev Wallace, P80922 on behalf of Mr. Brown.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court, Mohammed Nasser, P74485, also appearing on behalf of Jamar Brown. Your Honor, this is the date and time set for a preliminary examination. Mr. Brown has yet to arrive. We asked this honorable court to allow some further time. This is a young man that there were 2 other matters that were here that were dismissed, so he certainly has a vested interest in showing up. He was involved in a car accident. He was shot, so he does have some mobility issues. And speaking to my secretary, there was a conversation with him yesterday, and he said he would be here, so I have no reason not to believe he would.
You know, Your Honor, also, it's my understanding he was in this court yesterday on a different matter, or was scheduled to be in this court yesterday on a different matter, and may have, because of that occurrence, may have been confused about his, the necessity of being back here today. you might have heard, different dates.
Have you been in communication with him this morning?
We have not been in communication with him this morning.
This matter was set for 9:30. Unfortunately, we are under a time crunch, and there's a number of things that are going to take a significant amount of time. It may not look like it, but we're about to be into a whirlwind in a second here. If you're able to welcome in or procure his presence on Zoom before lunch, then I will reconsider what we're about to do. But it's now 10:04. It was set for 9:30. Is there a motion?
Yes, Your Honor. People would ask that this court would issue a KPS that long before the defendant remanded in custody.
Okay, KPS is going to issue, for the reasons I've just stated, it's now 10:05. This matter was set for 9:30. And if there were something more solid, certainly the court is, I look at the representations from defense or prosecution in the same manner, but there is nothing that is explaining why the defendant is not here. So with that being said, KPS is going to issue. Previous bond is forfeited. New bond is going to be set at $50,000 cash or surety with GPS tether. Anything further?
Your Honor, just for the record, all four of the people's witnesses are here and people will be otherwise ready to proceed. Given the KPS, do I have, may I excuse the witnesses?
Yes, because we will not be able to hold even if he walked in.
Thank you, Your Honor.
And Your Honor, if we are able to locate him, this court will allow us to enter via Zoom. I'm still here, actually, I have an exam at 10:30.
Oh, okay. All right, yes, if you are able to secure his presence, we're not going to enter the KPS just because we're going to be so busy until sometime after the lunch hour. So if you're able to get him to appear on Zoom, we'll set the KPS aside and put this back on track. But even if he were to walk in now, we're not able to conduct the examination because there just is not going to be time. How many witnesses did you have?
Four witnesses, Your Honor. I don't think they would take very long, though.
Okay, all right. We're going to process this KPS, and if he's able to Zoom in or appear otherwise, then we will put this back on track. Otherwise, after Madam Clerk enters the KPS, he will have to avail himself in the typical manner that anyone would when there's an open warrant.
Thank you, Judge.
Thank you.
Thank
Thank you, Your Honor.
Okay, Mr. Carlesimo?
Yes.
Irvin, are you ready?
Yes, Your Honor. I did want to ask you one quick question. Thank you.
I'm not sure.
That one quick question.
APA Simona?
Yes.
What
Hi,
case
good
are you-
morning. I'm here on Keith Graham. It's a CSC case. I'm told that I'm a prosecutor. It's not my case, but I'm here to help. It probably will be after today.
Mr. Quinn, are you available?
Who's handling?
Oh, he's here.
Irvin.
Mr. Lindsay, are you on Urban?
Yes.
Okay. Recalling Graham, case number 2158852, the people of the state of Michigan versus Derek Keith Graham. This case was previously called in full. It is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning. For the record, Nida Simona, Assistant Prosecutor for the people from the Sexual Assault Team, P45356.
Thank you.
Good morning, Judge. Christopher Quinn, P69483, appearing on behalf of Mr. Graham, who's appearing via video conference.
Thank you. Please state your name, sir.
Derek Graham.
Thank you. We're here today for PCC. What is your pleasure?
I have not received the discovery yet, but we can, if I can get the discovery, we can set it for exam.
So what, I don't know how quickly you can get the discovery. So do you want a new PCC in a week or do you want an exam?
The PCC in a week would work, Judge.
Okay, so let's say today's the 9th, July 16th will be the new PCC date. And from there, provided you have everything you need and you're ready to go, we'll set the exam.
Okay, sounds good.
Very good. Mr. Quinn, I will be in touch with you. I'm going to put my email in the chat. If you can email me your information, I would greatly appreciate it.
Okay.
Thank you.
Okay, anything further?
Thank you, Judge. Sorry
Thank
about
you.
the confusion this morning.
No worries.
Thank you.
Have a good day.
Are we ready on Urban?
Yes, yes, we are.
Is this gonna be a hold?
I don't know.
Okay, I mean, I just have like maybe 5.
Is it going to be a hold? If so, she needs to.
Calling parties on Urban, case number 2158878, the people of the state of Michigan versus Jamal Tavon Urban. The defendant is charged with count 1, robbery, unarmed, habitual offender, third offense notice. This is scheduled for a preliminary exam.
Thank you. Appearance, please.
Good morning, Your Honor. Rima Kuki on behalf of the people.
Good morning, Your Honor. Anthony Carlosimo. My PIN number is 25352. I represent Mr. Urban. He is present.
Please state your name. Thank you. Are we proceeding to an exam?
We are, Your Honor.
Thank you.
Yes, Your
We're gonna have to pause. That's what I was asking. Are we going to exam and nobody was responding? Please go ahead and take a break.
All right, thank
It was one.
Mr. Parker, what do you have?
Good morning. I just wanted to give you an update on my client, LaTanya Hickson, who the judge had ordered a tether on. She has checked herself in to Team Wellness, Team West on Ford Road in Westland. She did that yesterday. It's an inpatient treatment. And I'm going to be asking the court to modify that tether request order until she is released from that facility.
Okay, so that she would be tethered to that facility?
Can we just not do a tether at this point in time until she's released, upon release from Team West?
Can I trouble you to put that in a proposed order and forward it to myself and to the prosecutor so we
No
can look at
problem
the.
at all, Your Honor. I could do that.
Thank you. Okay, we're back on the record in the People versus Urban, Jamal Urban. This is 210-588-78. Appearances again.
Remax Group on behalf of the people.
Anthony Carlesimo, Your Honor, on behalf of the defendant.
And your name, sir? Any preliminary matters before we begin?
No, Your Honor.
How many
No.
proposed witnesses?
Just one.
I'm sorry, did you have any preliminary matters?
No, Your Honor,
Thank
thank
you.
you.
First witness?
People called Jamal Nixon.
Good morning, sir.
Good morning.
Could you please state your name and spell your first and last name for Madam Court Reporter here?
Jamal Nixon. Jamal Nixon, Nixon.
Thank you. How do you spell your last name?
Nixon.
Oh,
Nixon.
okay, thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. You can come on up here. There's a little gate, a half gate here that opens up towards you. And watch your step. There's a couple of steps to get up. Madam Prosecutor, once he's settled, you may proceed.
Good morning.
Good morning.
Please restate your name for the record.
Jamal Nixon.
Mr. Nixon, I'm gonna ask you a few
Can you put
questions,
the
but I-
microphone in front of you? Yeah, there you go.
I'm just gonna need you to speak up because we have a court reporter here that's gonna be recording everything that you're saying, okay?
Okay.
I'm gonna take you back to the date of June 8th of 2021. Were you at the location of 4040 West Warren?
Yes.
Is that in the city of Detroit, County of Wayne?
Yes.
What is at that location?
It's a gas station.
And did anything happen on that day that brings us to court today?
Yes.
Okay, tell me what happened.
I was in line playing my lotteries. After I got done playing my lotteries, I left the gas station and I saw a couple of guys approach,
And when you say you saw a couple guys approach you, in what direction were they approaching you?
coming towards me.
And when you say couple, how many is that exactly?
30.
3?
Yeah.
So they, what direction did you say they were approaching you?
They was coming towards me, so.
Okay, and did anything happen when they were coming towards you?
Yes, I took off running back into the gas station. The tall guy grabbed me. He tussled down and the tall guy grabbed my chain.
Okay, I'm gonna stop you right there. When you say a tall guy grabbed you, were you able to see his face at this point?
Yes.
And do you see that person here today?
Yeah.
Can you please point to him and describe something he's wearing?
The green, jail outfit over there.
Your Honor, may the record reflect that the defendant has been identified?
The record will reflect identification of the defendant.
Thank you, Your Honor. So tell me what happened when you saw Mr. Urban approach you.
He tussled to the ground and he grabbed my chain, I grabbed my chain. I tried to stop him from grabbing it. So he hit me in my head a couple times. For me to release my chain.
And did you see any other individuals that were around Mr.
There was
Urban?
a couple, there was 2 other guys, but I couldn't really get a good look at them.
Okay.
One grabbed my bracelet off my wrist, and the other one tried to go in my pockets, but he couldn't go in my pockets.
And when you said that Mr. Urban grabbed the chain on your neck, were you on the floor at this point, or were you standing up?
Yeah, I was on the floor. He was over me.
Okay, and was he able to remove the chain off your neck?
Yes.
Okay, and were any other, items removed off of your person?
Just my chain and my bracelet.
And what happened after those items were removed?
They took off running towards the car.
Who took off running?
Urban and his two, guys he was with.
And did you do anything after they took off running?
I tried to chase them, but they was already in the car and gone.
And what did you do after that, if anything?
I called the police.
Did the police show up?
Yes.
Did you make a statement?
Yes, I made a police report.
Nothing further, Your Honor.
Cross-examination.
Thank you, Your Honor. Mr. Nixon?
Yes.
Judge, I'm sorry, would you mind if the attorney used the
Yes,
microphone?
could you use the podium, sir?
Thank you.
And have the microphone that
Yes, thank you.
assists us.
Mr. Nixon, just a couple of quick questions. Did you know Mr. Irving before this date?
No.
You'd never seen him before?
Never seen him.
Okay. Now, you say that there was two other guys.
Yes.
When you described being put to the ground, were the other guys involved in that tussle as you described it?
Yes, as I got touched to the ground, that's when they came, that's when they approached.
Okay, all right. And you know that Mr. Irving was the one that removed your chain?
Yeah.
Okay. And who took the bracelet?
The other guy was with him.
Okay, but you don't know who that was, you didn't see him really, you couldn't identify him?
No.
But you got a clear look at Mr.
Yes.
Okay, thank you, I have no more questions.
Any redirect?
No redirect, Your Honor.
Thank you. You may exit the courtroom, sir. Any further witnesses for the prosecution?
No further witnesses, Your Honor.
Any witnesses for the defense?
No, Your Honor, no witnesses.
Is there a motion?
Your Honor, people move for a bind over and reserve argument.
I didn't hear the door close. Is the door open?
No, it's closed.
Oh, okay. I'm sorry, say again?
People move for a bind over and reserve argument.
Your Honor, it's leave it to the court's discretion, I think it's a question of fact for the jury.
It certainly is. This is a probable cause hearing. Mr. Urban, this is a probable cause hearing. The burden on the prosecution, can you stand up, sir? The burden on the prosecution is to establish by a probable cause standard only that a crime was committed in the city of Detroit, county of Wayne, and that you probably committed that crime. But the testimony that's been presented here by way of Mr. Nixon, prosecutor has certainly cleared that hurdle, and there is a question of fact that remains that needs to be determined by the fact finder if it's appropriate to do so, unless it's otherwise resolved. So with that being said, I do find that the prosecution has met their burden. The matter will be bound over to the circuit court for further proceedings. The arraignment on information date is going to be July 16th at 9 a.m.
July 16th, you said that?
July 16th, next Friday at 9 a.m.
Your Honor, I don't know where that's going to be, but my client already has a pending matter in front of Judge Bruce tomorrow. Would that be in front of him? Does anybody know?
We have no idea.
We won't be.
We just find it over there and then they
Okay.
take up the schedule.
All right, we'll figure it out. Thank you very much, Your Honor.
Thank you so much. Okay, can I trouble you, officer, to have Ms. Farkas come in?
I know.
Thank you, Judge.
Thank you, Mr. Carlos.
Have a good day.
calling case number 2056204. The people of the state of Michigan versus Lewis James Lee Houston. The defendant is charged with count 1, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic, 50 to 449 grams. Second or subsequent offense notice. Count 2, controlled substance, possession, cocaine, heroin, or another narcotic, less than 25 grams. Habitual offender. Fourth offense notice. This is scheduled for preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Anna Bickerstaff on behalf of the people, P82215.
And good morning, Your Honor. Neighborhood Defender Service by Stephanie Farkas, P74227, appearing on behalf of Mr. Houston, who's present and seated behind me to my right.
Thank you. Please state.
Good morning, Your Honor, Lewis Houston.
Oh, so I'm sorry. Say again.
Good morning, Your Honor, Lewis Houston.
Thank you. Are there any preliminary matters before we proceed?
Judges, the people would ask for a mutual order of sequestration with the exception for my officer in charge who's seated in the front row.
Okay. And that's your first witness next to him?
Yes, Judge.
Okay. Sequestration is going to be granted. The courtroom is pretty much sequestered because of COVID restrictions. So I don't know that there's any concerns inside of the courtroom. However, in the Zoom gallery, I am going to enable the waiting room. And if there's anyone that is remaining here, except for you, Mr. Malafite, we'll keep you there. Mr. Malafite, what are you here for, by the way?
He's got a motion here.
That's correct, Judge.
Okay, can you hold tight for a moment?
Oh, absolutely, Judge.
Thank you. Jonathan Camp, I can't read your full name, but I'm putting you in a waiting room. And the third tier 2 sequestration is that we are live streaming on YouTube. So if there's anyone watching the live stream that shouldn't be watching because you're either a witness or a potential witness, now would be the time to stop from watching the live proceedings to maintain the integrity of this process. Anything else preliminarily?
Judge, at this time, the people would move to admit people's proposed exhibit number 1 pursuant to MCL 76611B.
Any objections?
Judge, I believe it's permissible pursuant to the statute, so.
I just wanted to give you an opportunity to be heard. With that being said, that will be admitted as People's 1.
Thank you, Judge.
Please mark it. Do you have any other exhibits that need to be marked?
Yes. Yeah, that's fine. Yeah.
Anything further? Are there any, oh, is she still marking the?
Yes.
This case, it's got an exam date in December, we started today for probable cause, so we will get the tether. But they're trying to come up with the put the tether on, so we have nothing to do with it. So I'll just make a little note in the file.
Perfect. How many proposed witnesses do you have?
6.
6 witnesses?
Oh, I'm sorry. I thought you said exhibits. No. 2 witnesses. Sorry about that.
That's bad enough.
Okay. And Judge Peoples proposed exhibit number 1 may approach the bench.
Sure.
Sorry about that. I misheard you.
Oh, brother.
No.
We're in trouble.
Pardon? Pictures? Okay. Thank you. Oh, sorry.
Mr. Slusky, what are you in here for, sir?
Your Honor, I have Jordan Baruchko, Carol Brown, and that's it, Baruchko and Brown.
PCCs?
Yes.
Do you want me to send you?
Do you have corresponding attorneys?
Let me see, I've been in.
Carol Brown?
Yeah, so it's Brian Stock for Baruchko and Wayne Frost for Brown.
I got a date for Carol Brown, and Mr. Schloth is somewhere in the building. I told him he could come in and we could pick a date, and I never did see him.
I'm sorry, what was that thing?
Carol Brown has an exam date of 12:15 at 11 a.m. And Mr. Schloth is somewhere in the building. I told him he could come in, and he never did come in, so I'm not sure where he's at.
Okay, I've been emailing with him.
Okay.
We've been in communication, but.
Mr. Boomers, do you have anything quick?
Not this time.
Is your witness still here on McDowell?
Yes.
Mr. Chambers here yet?
I have not seen Mr. Chambers yet.
Okay.
I remember when we scheduled it, he had said he had something else going on, so it's tight.
Okay.
Well, he may have decided he didn't want it.
I'm calling. Are we all set?
Yes,
Okay, any other preliminary matters?
no, Judge.
Okay, first witness.
Thank you, Judge. At this time, the people would call Trooper Phelps to stand.
Oh, I'm sorry. Was there any objection to the officer in charge remaining in the courtroom, Ms. Farkas?
Not for purposes of exam, Judge.
Thank you. First witness.
Your name, please.
Yes, ma'am.
Okay. Yes, sir.
You can actually state your name at the podium where there's a microphone. If you could state your first and last name and spell both for Madam Court Reporter.
Yes. Sergeant Adam, ADAM, Falk, FALK.
Would you please raise your right hand? Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thanks, sir. If you come around towards me, there's a little half gate that opens up towards you. Just watch your step. Once he's settled in, you may proceed, Madam Prosecutor.
Thank you. Can you please state your name for the record?
Adam Falk, FALK.
And how are you currently,
I'm a detective sergeant with the Canton Police Department.
and how are you employed back on June 13th of 2018?
I was assigned out as a detective assigned to the Western Wayne Narcotics Investigation Team.
Okay, and back on that date, did you have the occasion to be in the area of 5031 Hereford Street in the city of Detroit, County of Wayne?
Yes, ma'am, I was.
And what did you do at that location?
We were executing a narcotic search warrant.
And did you recover some items at that location?
Yes, I did.
And can you please describe what happened when you approached that location?
The search warrant was actually executed by the State Police Emergency Support Team, so they made entry into the house for us. So we did not make entry until the house was secured.
Okay, explain to me what happened when you made it into the home.
Then the assignments are given out by the officer in charge on the scene, who's doing what as far as pictures, which rooms are being searched by who. So I was assigned just searching of the house.
Were there any individuals in the home when you executed the search warrant?
I don't recall there being anybody in there.
Did any individuals arrive while you were executing the search warrant?
Yes, they did.
Could you explain that?
Madam Prosecutor?
Yes, Judge?
Could I trouble you and opposing counsel when you're speaking, if you could go to the podium?
Oh, okay.
Thank you. There is no other device that's carrying your voice, so you have to use the speaker.
Sure, sorry about that. Could you explain what happened or who wrote at the house?
Yes, ma'am. As we were inside executing the search warrant and searching the residence, First Lieutenant Weimer observed a vehicle pull up into the front yard and identified the person driving as the defendant, Mr. Houston.
Was anyone with Mr.
I
Houston?
would say that's your side.
Objection sustained.
Did you observe anyone arrive at the house while you were executing a search warrant?
Yes, I did. The announcement was made that a vehicle had pulled into the driveway, and he as in Lieutenant Weimer requested assistance out in the front yard of the home we were at.
Okay, what did you do next?
Then I ran out there and assisted with securing Mr. Houston in custody.
Okay, so you observed someone outside the location, is that correct?
Yes.
And you see that person that you saw in court today?
Yes, ma'am. That's Mr. Houston. He's sitting with the white t-shirt on with lettering on the front and the mask.
Would the record please reflect that the witness has identified the defendant in this case?
The record will still reflect.
Was anyone with Mr. Houston?
There was a child with him.
Okay. And did you recover any evidence from inside the home?
Yes.
What did you recover?
From different locations, but I recovered drugs and residency.
Could you explain what drugs you recovered?
Suspected heroin from the basement. It was in a windowsill wrapped in some insulation.
And was that recovered and placed on evidence?
Yes, it was.
And do you recall the evidence tag number of that item?
Not the evidence tag number, no.
Will looking at your report refresh your recollection as the evidence tag number?
Yes, ma'am.
May I approach the witness?
Yes, ma'am.
You recognize what I've handed you?
Yes, ma'am.
What is that?
This is an incident report from the Michigan State Police.
Okay, if you could please look at that and let me know if that refreshes your recollection as the evidence tag number of the drugs.
Yes, it's property number 3.
Okay, did you recover anything else from the home?
Yes, I did by refreshing my memory from the report.
Okay, so if you are looking at the report to refresh your recollection, if you could please, if it's something other than the evidence tag number, if you could review the report, then put it down, and then questions will be asked.
Okay.
Take your time.
You mentioned
there's multiple tag numbers.
That's fine. You mentioned you recovered some identity documents, is that correct?
Yes, ma'am.
Could you explain what those were and where those were recovered from?
Yes, ma'am. So on items 10 and 11, they were also identity documents located in the home. One was located in the kitchen drawer, and others were located in the northwest bedroom.
Did those have names on them?
Yes, they did. Mr. Houston's name.
And what was the address on those documents?
The address of the search warrant.
Okay. Did you recover any other suspected narcotics or drugs?
Yes, I did. Approximately 15.8 grams were seized from the northwest bedroom also.
I didn't think you had, I just was assuming you didn't have an objection to it, because I have stated already that the appropriate way to refresh recollection is to review the report, then put it down, and then questions are asked. So I'll state that again. If it's something specific, like an evidence tag number or a specific quantity that you cannot recall, certainly I have no problem with him reading from it. But if it's a general question, like what, if anything else, did you recover? If he needs to refresh again, that's fine. Then he needs to put it down, and then you can proceed with the question again.
Yes, Judge. You testified that you recovered an additional amount of heroin, is that correct?
Yes, ma'am.
What was the evidence tag number of that item, if you recall? Without looking at your report, do you recall the evidence tag number?
No, I don't.
With looking at your report, help to refresh your recollection.
Yes, it will.
Okay, please look at your report.
Okay. Property number 15.
Okay. Did you recover any other drugs inside the location without looking at your report?
Yes, I did. Oh, I'm sorry. Drugs, no. Other residency. Yes, there was.
Do you recall putting an item on evidence tag number 16? Or would looking at your report help refresh your recollection?
Yes, it will.
Okay, please look at the report.
Okay. Number 16. Yes, I'm sorry. There was another item of narcotics that were seized.
Okay, and do you recall the approximate quantity of that evidence tag number? Would looking at your report help refresh your recollection?
Yes, it would.
Okay, please look at your report.
Approximately 2.3 grams of suspected cocaine.
Okay. And just to go back, you had indicated that you went outside when you got a notification and you noticed Mr. Houston in the front of this location, is that correct?
Yes, ma'am.
Did he make any statements when he was outside of that location that you recall?
I don't recall that.
Okay, I passed it.
I have a question. If I'm hearing correctly, there were 3 different places where you recovered suspected heroin. Or was it two? One was in the basement. The second, I didn't hear where it was recovered. And was there a third?
Yes, there was, I recovered and seized 3 different narcotics from different locations.
And what were those locations, other than the first one you indicated, the basement?
May I refresh my memory?
Yes.
Okay. One was from the northwest bedroom closet, that was property number 16. And then property number 15, by refreshing my memory, was from the northwest bedroom closet also.
Thank you. Any follow-up or?
Can I ask a couple more
Yes.
questions, please? Do you recall what other, if any other items were, strike that. Did you notice any other items in the northwest bedroom when you executed the search warrant? Personal items, or was it an empty room? If you recall.
I don't recall that.
Okay, I passed the witness.
Cross-examination.
Before you do, Your Honor, I'm sorry. You have a passage here. What's the name of the street again?
HEREFORD.
HERE.
FORD.
Thank you.
Yes, sorry.
Good morning, Sergeant.
Morning.
So you testified on direct, that you don't recall any other individuals being present when the warrant was executed. If you referred to the report, would that refresh your recollection?
Yes, ma'am, it would. I didn't draft the report, so that's probably why I don't recall that information being put in here.
Okay, may I approach, Your Honor?
Yes. Is it with his report?
Yes.
Oh, yes.
Does that refresh your recollection?
It does not. Like, from what I can remember, when the ES team secures the door, people get placed in different locations, so I don't recall those 2 individuals being there. I'm assuming they were. I don't remember them being at that location.
Okay, so you acknowledge that the report indicates 2 other individuals?
Yes, ma'am.
Okay. That were present at the location when the search warrant was being executed, correct?
Yes, ma'am.
And the one individual is named Zamir Mitchell, is that correct?
Yes, ma'am.
Zamir, I'm sorry.
Zamir, ZAMIER, Mitchell, MITCHELL. And then another individual was Aaron, AARON Mitchell, correct?
Yes, ma'am.
And Georgia, no. Withdrawn, sorry.
Thank you.
And you also found numerous other documentation indicating residency of other individuals in the house, correct?
Yes, I did.
And that included checks that were in the name of 2 different individuals, is that correct?
Yes, ma'am.
And one of those individuals was Sharonda Hines,
Yes, ma'am.
and then another individual was Brian Thompson, is that correct?
Yes, ma'am.
Okay. And you testified that, what's listed in the report under property number 16, that was found in the northwest bedroom closet, correct?
Yes, ma'am.
Can you describe where in the closet it was located?
No, I cannot.
Okay, if you refer to your report, would that refresh your recollection?
No, ma'am, because it doesn't exactly say like if it was in the corner or on the shelf or wherever it was just found in the closet.
Okay, but you're the one who personally found that and located it, correct?
Yes, I did.
And you don't recall where it was?
I'm sorry, ma'am, it was over 3 years ago.
Okay. Have you reviewed any photographs or anything before coming into court today?
Yes, I did.
Okay, and you still don't recall?
No, because there's a picture of us holding the narcotics in the closet, so specifically where it was found, I don't recall.
Okay, so the photograph that was taken is just not necessarily the location where the drugs were found. Is that correct?
May I review that photograph?
Would it refresh your recollection?
Yes, it would. Okay, so I see it by a piece of clothing, but
But again, it's just somebody holding it up, correct?
yes, ma'am, yes.
And again, not clear where exactly in that closet location the drugs were found. Correct?
Correct.
All right. And you said there was 2 separate items that were recovered from that northwest bedroom closet, correct?
Yes, ma'am.
And that goes for both of those items. You do not recall where within the actual closet they were located, correct?
That's correct.
And you testified that there was drugs recovered from the basement.
Yes, ma'am.
And you just said that it was hidden in the windowsill in the basement, correct?
Yes, ma'am, inside of some insulation.
Okay.
Wrapped up in some insulation, I should say.
Okay, so you had to physically remove the insulation and in order to see and observe the drugs, correct?
That is correct.
Okay. And the drugs that were found in the basement, that is the largest quantity of drugs that was recovered, correct?
Yes, ma'am.
And there was no identity documents for Mr. Houston found in the basement, correct?
I don't believe I found any. I think there was some, but not by me, no.
Okay. You did not locate or recover any identity documents from Mr. Houston in the
Correct,
basement?
I did not.
Did you do any search to try to determine any other occupants or residents of the house?
Can you clarify?
As part of your investigation and your involvement in this case, did you do any search of that location, the records of that location, to determine who any other individuals could be residing at that house?
I did not, ma'am.
Did you attempt to interview Brian Thompson at all?
I did not.
Did you attempt to interview Sharonda Hines at all?
No, ma'am.
Did you attempt to interview Zamir Mitchell at all?
No, ma'am.
Did you attempt to interview Aaron Mitchell at all?
No, ma'am.
I could have just a brief moment, Judge.
Yes.
I have nothing further, Judge.
Redirect?
Just briefly. This one, please. May I approach the witness?
Yes.
Okay, I'm handing you the 2 pictures defense counsel just showed you. Do those pictures fairly and accurately depict one of the locations where drugs were recovered?
Yes, ma'am.
And would it be fair to say that there were clothes in that closet?
Yes, ma'am.
And could you tell what kind or what gender clothes those are?
Male clothing.
Are they large or small?
Large.
Okay. I have no further questions.
Thank you. Any follow-up?
No, Your Honor.
Thank you.
Thank you. Thank you, ma'am.
All set.
people would call Trooper Jirache to the stand.
So please state your full name and spell your first and last name for Madam Court Reporter.
John Jirashi, G-J-O-N, last name G-J-U-R-A-S-H-A-J.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Can you have a seat in the stand?
I'm sorry, can I just confirm you did say D-J-O-N?
G as in George.
Oh, no, D M.
No.
Okay. G-O-N?
G-J-O-N.
Okay.
You're a witness?
Thank you. Can you please state your name for the record?
John Jirashi,
And how are you currently employed?
Michigan State Police.
Are you with a particular unit or group?
At the time, it was Western Lane Narcotics, and which has since dissolved and turned into Metro Narcotics Enforcement Team.
Okay, and back on that date, were you at the location of, back on the date of June 13th, 2018, were you at the location of 5031 Hereford Street in the city of Detroit County of Wood?
Yes,
And, did you have the occasion to field test some of the narcotics that were recovered from that location?
yes,
And did you have the opportunity to field test an evidence tag item number 16?
can you repeat that?
Did you have the chance to field test evidence tag item number 16?
Yes.
And do you recall what that item field tested for?
Heroin.
With looking at your report, refresh your recollection as to what it tested positive as?
Yes.
May I approach the witness?
Yes.
Do you recognize what I've handed you?
Yes.
What have I handed you?
This is my police report.
And did you have the occasion to field test tag item number 16?
Yes.
What did it test as?
Cocaine.
Okay, and did you recover any evidence from this location?
Yes.
Did you recover?
A T-shirt from the closet.
And I'm going to approach the people's proposed exhibits 5 and 6.
Judge, I would just object to the admission of these two exhibits. They were not included as part of my discovery packet, and I just saw them this morning.
Your response?
I didn't realize they were turned over. I thought she had all the pictures. It appears she only had some of the pictures. I did have an opportunity to show her before we started the exam, and I believe she showed them, or looked at them with her client. They're just two pictures.
They're photos?
They're photos of an item that was recovered from the house.
The objection is noted, but the proposed, I'm assuming 2 and 3?
They're actually marked as 5 and 6, Judge.
5 and 6 will be admitted as 5 and 6.
Thank you, Judge. May I approach the witness?
Yes.
I'm
Are
handing
you
you.
seeking to admit them?
I'm seeking to admit them,
okay.
Judge, yes. I'm handing you people's proposed exhibits 5 and 6. Do you recognize what I've handed you?
Yes.
And what have I handed you?
This was the property that I found in the closet.
And would that be a picture of the item?
It's a picture of the T-shirt that I recovered from the closet.
And does that picture fairly and accurately depict the picture that, or the item that you recovered from the closet?
Yes.
At this time, I would move for the admission of people's proposed exhibits 5 and 6.
Will be admitted.
And where did you recover that T-shirt from in the home?
Hanging in the closet of the, I'd have to look at my report for the exact north, east, west.
Okay, please look at your report to refresh your recollection.
It was the northwest bedroom
And
on the
permission,
top shelf.
thank you. And permission to publish those items to the court, Judge?
Yes.
Can you just slide them under the thing?
Thank you.
People with past witness.
Cross-examination.
And Judge, if I may have those exhibits back when the court is done reviewing them. Thank you, Judge. So, good morning, Trooper.
Good morning.
So exhibit 5, it all says the word daddy and daughter, and then best friends for life, correct?
Yes, ma'am.
Okay, can you describe where that photograph, or where that came from?
That was, what do you mean where it came from? That was on a T-shirt. It was printed on a T-shirt, like a custom-made shirt.
Okay. So the photograph is actually a T-shirt, and then this is the photograph of like the front screen print of the T-shirt.
Correct. All I did was, remove the shirt from the back, put the property label next to it, and I just took a picture of it.
Okay, and do you recall where in the northwest closet you recovered this shirt from?
On the top shelf of the closet.
Okay, was it folded?
I don't recall, it was just at the top.
Okay. So it was not one of the shirts that were hanging, on the rack on a hanger or anything?
Correct.
Okay. I have nothing further, Judge.
Any redirect?
No, Judge, thank you.
Thank you so much.
Judge, do you want these back, or do you want me to remove them?
I've looked at them thoroughly, thanks.
Thank you. The people have no further witnesses at this time.
Madam Defense, is
No witnesses, Judge.
there a motion?
Judge, the people would move to bind the defendant over on the counts containing the information. The people would save their arguments for rebuttal.
Counsel?
Judge, we would object to the bind over. Your Honor. Oh. Judge, I would object to bind over. Your Honor, the people have essentially, claimed proximity, with some circumstantial evidence in terms of identity in this house. The testimony that the court heard today is that there were at least 4 other individuals that were residing in that household. In terms of the drugs that were found in the basement, you actually had to remove the insulation, and it was not easily visible that the drugs were in that window seal where they were recovered from. The detective testified that he did not recover any personal information or identifying information from Mr. Houston in that basement. In terms of the other drugs in that location, again, Judge, there's numerous individuals that resided in the house. The people's argument is essentially proximity, which for what I'm guessing is a constructive possession, which I think is insufficient at this point for the court to bind over, because a person's presence by itself at a location where contraband is found is insufficient to prove the constructive possession. We do have the mail items that, the identifying items that the detective did recover. However, they did not indicate specifically how long they were there for. Again, there's multiple people living in that household, and I would ask the court to quash the charges.
Thank you. I heard testimony presented by the prosecution, and including 2 officers that testified as it relates to their involvement with this narcotics search warrant and the actions that they took. This is a probable cause hearing, Mr. Houston, and as such, the burden on the prosecutor is to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes. It's a low burden. People don't like it, but it is what it is. It's a much lower burden than is required at the further stages of any legal proceedings. And it is what it is, and I need to make an assessment as to whether or not a question of fact has been presented. And certainly with the testimony that's been provided here, there is a question of fact. There has been sufficient testimony that's been placed on the record as it relates to the narcotics that were recovered, tagged, tested, and the proofs of residency, the specificity with which where the narcotics, the suspected narcotics were recovered from, and there was no question as it relates to the identity of yourself from the first officer that testified. So with that being said, I am binding the matter over to the circuit court for further proceedings with an AOI date of July 30th at 9 a.m.
Thank you, Judge.
Thank you. Is there anything further?
Nothing on behalf of the people.
I've handed your exhibit back to Madam Clerk. I don't know if you've received it yet.
I did, Judge, thank you.
Mr. Nasser, did you have a matter that was ready?
We do, Judge. Also, we located Mr. Brown, and he's on Zoom. Hoping I can address that, please.
Yeah, and we have, Woodward, and it's gonna be a full. With Mr. Nassar.
We have in custody, Judge.
We have another in custody. Okay, whichever's in custody is ready, we should bring that person up.
He's on his way.
Oh, okay, perfect,
Have a
thank
good
you.
weekend, everyone.
You too, thank you, Ms.
I don't know if
Marcus.
there's something quick.
Your Honor, we're on Bedell too. Ready on Bedell.
Is it in CC?
It's an exam.
This is here, prosecution?
Which case? Bedell?
Liddell.
That's mine, you can go ahead and call. No, it's a decline prosecute.
Okay.
Calling parties on Liddell, case number 21580. People of the state of Michigan versus Michael Javar Bedell. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, firearms, possession by felon. Count 3, weapons, firearms, discharge in or at a building. Count 4, 5, and 6, weapons, felony, firearm. Count 7, domestic violence, habitual offender, second offense notice. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Edward Taylor, P57166, appearing on behalf of Mr. Bedell for the attorney of record, Robin McCoy. Good morning.
Thank you. Morning, and is your client present?
He should be on, Your Honor. Mr. Bedell?
Yes, sir.
All right, state your name for the record, please.
Michael Bedell, Javar Bedell.
Thank you. Today is the date and time set for an examination. Are we prepared to proceed?
Your Honor, well, I would just, for the record, I'm gonna call out the complaining witness. This was a Zoom exam. Erica Benjamin, if you are on the Zoom gallery, please unmute yourself and state your name. Erica Benjamin.
Hold on. Let's try and get it. Nope, that's the prosecutor.
Your Honor, I did speak with the complaining witness on July 2nd, at which time she stated she no longer wished to go forward and would not be present at today's examination. Without her presence and participation, people are unable to move forward at this time.
Is there a motion?
Move for dismissal, Your Honor.
Thank you. That motion is granted. The matter is dismissed without prejudice as the complaining witness has failed to appear. And Mr. Taylor, do I have permission to sign your name to the order of dismissal as the moving party?
Yes, Your Honor.
Okay. And Mr. Bedell, do you have on a GPS tether that needs to be removed?
No, Your Honor.
Okay. We're going to forward a copy of this. Should we forward it to Ms. McCoy? Mr. Taylor?
Yes, Your Honor, that'd be great.
We're all set here. Thank you so much.
Have a good weekend.
You too.
All right, bye.
And who is Ms. Bates, or who's representing this gentleman?
Ms. Bates is on.
Oh, what did you want to do? Is it real quick on Jamar
Yeah,
Brown?
that's Mr. Brown that's on Zoom, so I wanted to see if I could recall that warrant, but I'm also here on Woodward, which further counsel and I are ready to proceed.
Who has the in custody?
Okay, oh, sorry.
Okay, we're gonna call that as soon as we do this quick Brown matter. I think it's
Yeah, he's on, prosecutor.
Recalling Brown, Jamar Brown, case number 2061517. This case was previously called in full. It was scheduled for a preliminary exam this morning.
Thank you. Appearances, please.
Morning, Your Honor. Jonathan Lysak, P74620 on behalf of the people.
Good morning, Your Honor. Ted Wallace, P80922 on behalf of Mr. Brown.
And good morning, Your Honor. Once again, for the record, Mohammed Nasser, P74485, appearing also on behalf of Mr. Brown, who also appears via Zoom. Mr. Brown, please identify yourself for this court.
Jamar Brown.
Thank you. So today was the date and time set for an examination. It was 9:30 this morning, and you were not here. I'm glad that you have appeared via Zoom, but because otherwise there would have been a warrant that would have been issued for your failure to appear here today. So I'm going to set that habeas aside. It hasn't been entered, but for the record, the language should indicate that the habeas will be set aside. We do need to get this back on track. The defendant, Mr. Brown, is not in custody, so there is no way that we can accommodate anything in the near future. Madam Clerk? Given the nature, though, of these allegations, I don't want to put it too far out.
You mean what?
September. While she's looking for a date, Mr. Brown, why were you not here?
I was released from the hospital at like 7:30 this morning. I had fell asleep and didn't wake up on time.
Oh.
I apologize, Judge. He was in the emergency room. As this court is aware, he was involved in an accident, also a victim of a gunshot. Arm was injured. He's still receiving treatment and recovery, and he went to the emergency room related to that.
Okay.
So September 24th at 9:30.
Judge, I do have, I guess we could probably make it work with brother counsel was here, but I do have a jury trial scheduled on that date if it's going to go.
Okay, we'll do a different date.
Can you do September 23rd at 9:30?
September 23rd. Yes, we can.
New in-person examination date, September 23rd at 9:30. Mr. Misick, that date works for you?
That works for me, Your Honor.
Thank you.
Thank you, Judge.
Any other concerns to address?
Nothing from the people, Your Honor.
Your Honor, with the previous bond conditions go back into. Okay, I just wasn't sure. I know the capias was.
Yeah, set aside the capias, but thank you though. As a matter of record, let me indicate that the bond that was previously in place with the setting aside of the capias is automatically going to be reinstated. I'm not even going to prepare any paperwork to that effect because we didn't actually enter the capias yet. But thank you though. For the record, I should state that the bond that was previously in place is still in place now. So please make sure you abide by those terms. You understand, Mr. Brown?
Yes, ma'am, and thank you.
Thank you. Okay, thank you for reminding me of that, Mr. Wallace.
Thank you.
Okay, well, yeah, are we all set on that, Ellen? We can break it. Who's the prosecutor?
Mr. Blues. Calling parties on Junka. Did you say your name for me? Junka. Junka? Okay. Case number 2158710. The people of the state of Michigan versus Nick Junka. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, domestic violence aggravated. Second offense notice, habitual offender. Second offense notice, this matter is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Lears on behalf of the people.
And good morning, Your Honor. Melanie Bates, appearing on behalf of Mr. Nick Junka, who is behind me.
Thank you. Please state your name. Thank you. All right, we are here today for an examination. Are there any preliminary matters?
Your Honor, at this time, the complaining witness, Doris Saravio, is not here without her, she was subpoenaed to be here for an 11 a.m. examination. Without her present participation, people are unable to go forward at this time.
Is there a motion?
Your Honor, I will dismiss the case.
Okay. The matter is going to be dismissed without prejudice as this matter was set for an examination here today. It was set for 11 o'clock. It's currently 11:13 in the morning. And the representations have been made by the prosecutor to the extent that they cannot proceed. So I am going to grant that motion. I need your signature, Ms. Bates, on this order that I'm preparing right now. Keep in mind that this is dismissed without prejudice, which means that it is possible that the prosecution can reissue. If you have questions about that, please make sure you speak to your attorney and she will explain it to you in greater detail. Is there anything further?
Nothing for people, Judge.
Nothing further, Your Honor. Thank you very much.
Hi, this is Amy John calling from and you filed an appearance on a Jordan.
Is what your client is in here?
Oh, yeah, he's actually sitting outside.
Oh, he can come on.
I can call him, yeah, thank you.
To.
Is Mr. Chambers here?
233-000.
Mr. Bloomers, is Mr. Chambers here yet?
I haven't seen him out there yet.
Okay.
Judge, I don't know if Mr. Malafide, it's a property. He had filed a motion.
Can you ask him is there any objection from the prosecution? Because
Did you have any concerns about this motion, Mr. Malafide filed?
we're gonna have, Mr. Bloomers take a look at it real quick. We just have to keep moving. And we're gonna call it after the prosecutor has looked at the motion.
Hold on.
Mr. Malafide.
What case am I supposed to be calling? Hold on, what's that signature?
Dante Woodward.
What is it?
Dante Woodard.
Woodward, yeah.
Woodward, yeah.
People versus Dante Woodward. This is 190-60894. The defendant, Dante Woodward, is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, domestic violence. Defendant is listed as an habitual offender, second offense notice. Today is the date and time set for preliminary examination.
Yeah, no.
Can I have appearances first?
Jacob Bloomers on behalf of the people.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court, Mohammed Nasser, P74485, appearing on behalf of Mr. Dante Woodward, who also appears standing behind me to the right. Sir, please identify yourself for the record. Your Honor, I'm also assisted by co-counsel attorney Theodore Wallace.
Good morning, Your Honor. Ted Wallace, P80922, on behalf of the group.
Good morning, sir. Okay, any preliminary matters before we begin?
None from the people, Judge.
I'll just ask for a sequestration order of any all testifying witnesses.
Sequestration is granted. I'd ask the court to let me know if you see, I don't see anyone in the Zoom there's no one in the Zoom gallery, so it's other than an attorney or people working the courtroom. But if there is anyone watching the live stream on YouTube, you should now stop from watching the live stream if you are a witness or potential witness to maintain the integrity of this process. First witness.
Your Honor, the people call Donna Patrice Harris to the stand.
Yeah.
I got it marked already.
Well, no, I have to initial with it. We have more, this is number 1.
Good morning. If you could please come to the podium and state your full name and spell your first and last name for the record.
Donna Harris, DONNAHARRIS.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. If you have to make your way over here, there's a little half gate that opens up towards you. You could walk up the steps, and when you sit down in the chair, if you could pull the microphone down so that we can hear you better. Mr. Prosecutor, your witness.
Good morning, Ms. Harris. On the date of October 14th, 2019, were you?
I'm sorry. Would you please state your name again for the record?
Yeah. Would you please state your name, your full name for the record?
Donna Harris.
Okay, Ms. Harris, on the date of October 14th, 2019, were you at the address of 18459 Hubble Street?
Yes.
And is that in the city of Detroit, County of Wayne?
Yes.
And how do you know that address?
I stayed there for years. I owned the house at the time.
Okay. Do you live there now?
No.
Okay. And when you were at that address, was there anyone else with you that day?
I was at home by myself.
Oh, yes, put your mask on.
Thank you.
But yeah, be careful, you know, I know it'll slip from your nose sometimes when you're talking, so just try to keep it up. Okay, so, I asked you if there was anyone else with you at that address on that date.
Besides Dante, I was home by myself.
Okay, well, no, you said besides Dante, so you're saying there was another individual there?
No, I was home by myself besides when he came.
Okay. Now, when you say Dante came, who was that?
My son's father.
And what's his full name?
Dante Woodward, Dante Rashad Woodward.
Okay, and do you see, Mr. Woodward here in the courtroom today?
Your Honor, please stipulate identification.
I'd like for her to make an identification. Thank you so much, though.
Do you see Mr. Woodward here in the courtroom today?
Yes.
Could you please point to him and tell the court what he's wearing?
Dante, white collar shirt.
Okay.
From.
Let the record show that the witness identified the person as the defendant.
The record will reflect identification of the defendant.
Okay. And so you said that Mr. Woodward, you have a child in common?
Yes.
All right. And you said he came over to the house. So about what time of day was this when he came to the house?
It was in the morning. Right, a little after he dropped the baby off at school.
Okay. So when he comes to the house, what happens next?
Well, he knocked on the door and asked me, can we talk? I told him no. He insisted, so I let him in. I opened the door, let him in. He came in talking calm first and then started yelling and then started hitting me.
Okay, so I'm gonna stop you there. You let him in the house and you said he started hitting you. Where is this taking place?
In the kitchen.
In the kitchen. Now, did you let him in a door through the kitchen or?
The front room, the front door. The kitchen is an open kitchen.
Okay.
So I let him in the front door. We were in the kitchen. He wanted to talk. He started yelling, getting angry.
Okay.
And then it started escalating.
And you said he started hitting you?
Yeah.
So, now how is he hitting you?
First he punched me, first he pushed me up against the wall, slapped me, punched me, yelled some more.
Slow down just a little bit because we're all taking notes here.
Okay. Okay. Well, he, came in, started, yelling at me first. I'm asking him to calm down. And then he's, pushing up against the wall, started hitting me. He punched me, slapped me, punched me to the floor.
Okay, I'm gonna stop you there. When you say he punched you, was that with a closed fist?
Closed fist.
Okay. And you say he
slapped me with his open hand.
All right, and then you said he hit you to the floor?
Punched me to the floor.
He pushed you to the floor?
Punched
Okay.
me to the floor.
And what happened after he punched you to the floor?
I tried to get up and there was a pot on top of my stove. It was, when you're cooking, you got cooking grease in there. He poured that on me first.
Okay.
Then he started whacking me with the pot.
Okay, so, I'm gonna stop you there. You say he poured grease on you. Was the grease hot at the time you poured it?
No, it wasn't hot.
Okay. And, about how big was the pot? What kind of pot was it?
It's when you cooking holiday food, them big old round pots, steel pots, the good stuff, heavy, that.
You have a handle on it?
Yep, I still have the pot.
And you said he started hitting you with the pot. Where on your body did he hit you?
Outside my head, he hit me so hard it made a dent in the pot.
Okay, and did he hit you more than once with it?
Yeah.
Okay.
Yes?
Yes, yes.
And did he hit you anywhere besides the head with the pot?
He was just knocking me inside my head with the pot.
Okay. Did you suffer any injuries from the pot?
Yes.
Okay.
I damn near went blind if he would have kept going.
So what kind of injury did you suffer?
I had a hole real big in my face above my eye, right in this area.
And I'm gonna stop you just right there. I'm holding what is marked People's Proposed Exhibit 1, and I'm showing the defense counsel. May I approach the witness, Judge?
Yes.
Yeah.
Go ahead and take that from me for a second. Thank you. So I just handed the witness Proposed Exhibit 1. Could you please tell me what you're holding there?
A picture of my face.
Okay.
After the hospital cleaned me up.
And is there one or two photos on there?
Two.
Okay, and are those photos a fair and accurate depiction of the injury you suffered on that day?
Yes.
Okay, the people would move to admit as Exhibit 1.
Any objection?
Not for example, Mr. Judge.
Will be admitted as People's One.
And permission to publish to the court?
Yes.
Okay, so after he hit you with the pot, what happens next?
I was begging him to stop. He wouldn't. The neighbor down the street was looking around outside the house because I was in there screaming and all the loud noise. And then I'm like, Dante, stop. I'm not gonna tell him to just leave, and he already know. And
Okay, so at this point, have you called the police or anything?
I couldn't. He took my phone and broke it.
Okay. And so you just testified you were telling him to leave.
I kept asking him, begging him to leave. I was on the floor bleeding on my head.
Okay. Does he eventually leave?
Yeah, he left because the neighbor was outside looking around the house, like I said, and I told him that the neighbor was a cop.
Okay.
And I'm not gonna tell on you, so just leave. So after a while, he waited till the neighbor, went back home and the coast was clear and he left. Told me he was gonna come back and kill me, cause I gotta die.
Okay.
And then.
So I'm gonna stop you there. After he leaves, what do you do?
Hopped in my car and went around to my mom's house. And then, I ended up going to the police station and to the hospital.
Okay, and so did you report this incident at the police station?
Yes.
Okay, and then you say you went to the hospital?
Yes.
And were you treated for injuries?
Yes.
Okay. No more questions at this time, Judge.
Thank you. Cross-examination.
Your Honor, if I may.
Yes.
Good morning, Ms. Harris.
Hi, good morning.
Ms. Harris, I'm gonna ask you some questions, and if you don't understand, please let me know, and I'll try to rephrase it in a way that you can understand. Is that fair?
Mm-hmm.
Now, Ms. Harris, you've already testified that on or about October 14th of 2019, you were at your home on Hubble Street, correct?
Yes.
And did you reside there with Mr. Woodward?
No, he didn't stay there, I stayed there.
Okay, and you testified earlier that you have a child in common with Mr. Woodward, correct?
Yes.
And did that child stay at the house with you, ma'am?
Did the child stay in the house with me at the time? Yes.
Yes,
One
okay.
for my kids though.
Okay, now, was the child home during this alleged incident?
No, he dropped him off at school and came back.
How old is your child?
He will be 8 years old on the 28th of this month.
Okay, so that was he was about 6 back then, is that correct?
Yeah.
Okay. And you said that this was sometime early in the morning, around 10 o'clock or so?
Yeah, early in the morning, yes.
Okay. And at this particular time now, did Mr. Woodward have a key to this house, or you'd have to let him in?
No, he didn't have a key to my house. I had to let him in.
Okay, so is your testimony here today that there was some type of argument that ensued between yourself and Mr. Woodward, correct?
The argument started, he gets loud and angry and wants to fight when he's mad.
Okay, but the question is, there was an argument that occurred between yourself and Mr. Woodward on this day, correct?
Yes.
Okay, now, did this argument, was there any, let me ask you this, you said that Mr. Woodward actually dropped the child off to school, correct?
Yes.
Okay, so that means he came to your house to pick up the child first, or did he stay with you that night?
No, my son was with him. He actually had our baby over the weekend. He dropped him off at school.
Okay.
Then he came back to my house wanting to talk to me.
Okay, so was there any preamble, was there anything leading up to this argument? You guys had a discussion prior to him trying to come into your house, correct?
I mean, only thing it was, is I didn't want his, I had a situation that occurred in my house back in 2016.
Right.
So my thing is, I don't want nobody at my house or know where I stay at. So I don't know like what his issue was, but he would try to make me mad by bringing people to my house. So I just asked him not to bring nobody to my house.
And these were women that he was sleeping with, right?
I guess at the time, she was his girlfriend.
Okay, so there was multiple women or girls that he would bring by the house, and you didn't like that, right?
No, I ain't gonna say multiple.
Okay, but there was
relevance.
I'm trying to figure out the relevance.
It's absolutely relevant, Judge. We're talking about the preamble that led to this alleged argument. We're talking about a discussion about, other women, and this is a domestic situation in which there's a dating relationship, so there's.
We weren't.
Hold on.
So, I'm speaking to.
I'm gonna allow you some leeway, but I mean, we could be here all day talking about issues that could potentially cause people to get excited.
Right.
That have had a prior, relationship with one another.
Absolutely.
So, this is kind of a slippery slope, but, okay, is there much more along the lines of that?
Not much.
Okay.
Okay, so it's your testimony that you didn't like the fact that he was bringing another girl or girls by
No,
his house, right?
that wasn't the case.
Okay, it wasn't the case at all?
No, the thing was, I didn't, listen, my ex was murdered at my house, okay? So I did not want nobody at my house. And he knows that. Even when me and him stayed together, I didn't even want his friends coming to the house, because this is Detroit, we lived in at the time.
Okay, but
And it's
I'm
rough.
sorry to cut you off, but there was an issue with him bringing a girl by your house or waiting
It was
outside,
issue with him bringing anybody to my house.
including a girl, right?
Anybody.
But the question is including a girl,
It's
right?
anybody, sir.
Okay, so are you gonna answer the question?
I just said anybody, sir. She's
Including-
included.
One at a
Any
time,
women.
please, one at a time, please.
Including a girl that he was in a relationship with, right? Yes or no?
I just said anybody.
Yes or no?
I don't know if you're trying to make this about a female or not.
I'm
but
not trying
I
to
don't
make
get
it about
where you're
anything. Can
going.
you answer the question? Yes or no? Did that include?
I said anybody, so I don't know how you're gonna take that.
I asked the questions, not you. So answer the question, yes or no. Does that include a girl that he was dating with at the time?
Anybody. He brought it to the house
Yes
before.
or no?
Now, Mr. Nasser.
I don't know what anybody means
Hold
to
on,
him.
hold on, excuse me. Mr. Nasser.
Judge, I'm trying to elicit a very simple question, and I'm not getting, I did get the
You're not
answer.
getting the response that you want. We are not going to sit here while you continually ask the same question over and over.
I would ask you.
Her response was, anybody. That is her response.
Okay, I'll move on. All right, so on this particular date, you've already testified you let Mr. Woodward into your house, right?
Yes.
Okay, and it's your testimony that ultimately this is an individual that you've had a pre-existing relationship with, right?
Back in 2014.
But you have a child with him, right?
Yeah, that was years ago, sir.
Okay, years ago. You still have that child, right?
Yeah, but the relationship died.
Okay, so
years
just
ago.
listen to the question, man. I'm saying, so you have a child with him today and back in 2019, right?
Yes, I have a child with Mr. Woodward.
Okay, and you guys had a situation where the child was being dropped off to school and visiting his father, right? Back in 2019.
Arrangements I made because he didn't want to actually get his child unless I was messing with him. But I'm trying not to be emotional and cry right now, but you pressing my buttons, you really is.
Well, I'm asking you very simple questions. You don't have to get emotional about it. I'm asking you a
You
very.
pushing it, go ahead.
Okay. It's a very simple question. On that particular date, you've already testified that he dropped your child and his child to school, right?
Yes.
And then he proceeded to come to your house, right?
Yes.
Okay, and he knocked the door, agreed?
Yes.
And at this point in time, you guys are not involved in a relationship, is that correct?
Right.
Okay, because, he's seeing somebody else, perhaps you're seeing somebody else, but you guys are not in a relationship, right?
Right.
However, you would agree that you let this individual into your house, right?
Yes.
Okay, and after you let him into your house, you guys got into an argument, right?
Sure, yes.
Okay, and things got heated, is that fair?
Yes.
Emotions are running high like they're running high right now?
His emotions was running high. I was scared.
And so you're just telling me your emotions don't run high like they're running high right now?
His emotions were running high. I was scared.
And you were calm, right?
I mean, what are you doing? Somebody that's about to take your life. Tell me how you play.
You don't ask the questions, ma'am, I do. I'm asking a simple question. You were emotional like you are today, right?
Do you understand this is not my first incident with Mr. Woodward? Do you understand that I've been through this situation with him before? Do you understand that he's trying to take my life? I have 2 fucking kids. And you trying to sit up here and talk to me like this nigga not fucking wrong? Do you hear yourself? You asking me stupid ass questions. I'm giving you every fucking answer you ask me for it to stop.
All right. Now, listen, there is an expectation that the court has with anyone that's inside of this courtroom. That's number one.
I'm sorry.
However, Mr. Nasser, I will say, I don't know if this was the response that you were looking for, but you were asking very, very pointed questions that were leading us to this very point.
Exactly. The point is, I'm just showing the emotion. She can't answer a simple question. I'll direct this court.
I'm not sure if the court understands the point that you've made. I don't know if we're picking up the same point.
The point is, Judge, is that it was an emotional situation and emotions were running high on both ends. That's a simple question.
And she never acquiesced to that. She didn't say that. She said that she said that she
And I
was
said-
scared, and you want her to say something different.
No, I don't.
And you're continually nudging the situation to the point where there's an explosion now. Now, I'm gonna ask you to make sure that you maintain yourself and have a level of decorum about you in this particular courtroom, okay? In any courtroom. But Mr. Nasser, you can't keep poking the situation and expect not to have an explosion like this. And I think that the point that you think that you're making, I'm not certain that it's the same point that the court has picked up.
Well, Judge,
So I would just ask for us to please move on.
Absolutely, Judge. I would ask this court to direct Ms. Harris to answer the questions and.
Well, hold on, and I did ask her to act with a level of decorum. But I'm not going to instruct any witness to answer give the answer that the defense attorney keeps trying to get, if that is not her answer.
Okay.
So the question repeatedly gets asked again and again because you're not hearing the verbiage that you want. And that is not fair either, or appropriate. So, well, again, I would ask that you maintain a certain level of calmness in the courtroom. If you need to take a moment, we'll take a moment. You can have some water and step into the hallway. But I would also ask that you not continually ask the same question over and over to gaslight the responses that are being given here.
Yes, Judge. May I proceed?
Yes.
Well, Judge, if I could, I just want to put my objection on the record, ask and answer.
Objection sustained.
Okay, may I proceed, Judge?
Yes.
All right, so Ms. Harris, you've already testified that this individual came into your house and he was emotional, correct?
Yes.
Okay, and your desire was.
He wasn't emotional at first. He got emotional when he started fighting me because I wouldn't agree to what he was saying.
Okay.
That's when he started acting retarded.
Okay, so he came in, originally there was a calm discussion between you two, right?
Not really, no.
Okay, so clarify what you meant then. You just said he came in and originally.
He came in talking slow and calm at first, and
Okay.
it was a half a second. Then he started yelling at me.
Okay.
Then he started whacking me.
Okay, so when he walked in and you guys had a discussion, agreed?
He had a discussion.
Okay, so he was talking and you were not saying anything?
No, what do you do?
Okay, again, I asked the questions, man. So it's a very simple thing. So he's talking to you and you're not responding, agreed?
When you were in a situation where you see how.
Objection sustained.
Okay. He's talking to you.
Are you gonna ask the same question?
No, Judge, I'm not getting any answer, let alone the answer that I want.
She answered no.
Okay. I don't believe she did, but she did, okay. So at some point in time, this argument gets escalated. Well, this discussion, one-sided discussion through Mr. Woodward to you, gets escalated to the point that he's yelling at you, right?
Yes.
Okay, and at that point in time, where are you situated in the house?
In the kitchen still. My kitchen is big.
Okay, where is he?
In front of me.
Okay, so he's also in the kitchen.
He's overpowering me, yes, in the kitchen.
Okay, when you say, I'm talking about.
When you yell at your dog, don't you just sit there and whine?
I don't have a dog.
When you yell at a dog,
Okay,
do it
I don't yell at dogs. I answer questions, man.
Please don't ask questions.
Okay, so where's your phone at the time?
I didn't have it.
You did not have it?
No, I didn't.
Okay, so that's why, at this point in time, did you make any efforts to call the cops?
How can I when he took my phone?
Okay, so let's get to that. I just asked, did you have your phone? You said no.
No, I did not have my phone. It was probably in the kitchen somewhere. But he took the phone when he came in.
Okay, where was the phone originally?
It was in the kitchen. He took my phone.
Okay, so that was not part of your original version of the events. So let's go back again.
That was my original version of the events. He took my phone.
Okay, so he entered through the kitchen. Yes?
Yes.
Okay, he grabs your phone
He
before
didn't
he
just
talks
grab
to
it
you.
off Brett. First, he got there assaulting me first.
Okay, assaulting you first. Then he grabs your phone.
I don't know where you're getting it.
Well, if you listen to the question, he grabbed your phone, correct? Did you see him grab your phone?
Yes, I see him grab my phone.
Okay, how many phones do you have?
I only have one.
Okay, let me ask you this. How many entrance or exits are in this house?
2.
Okay, did you make any effort to leave your house?
Yes, I did.
Okay, and he blocked
And he
you?
knocked me out with the pots.
Okay, so.
Every time I try to run, you gotta understand, he poured grease on me, okay?
Okay.
That means my whole kitchen floor, I have pictures. You want me to show you guys in my phone? I have pictures of my house looking like a murder scene because blood was pouring out my head because he poured grease on me first. So understand how slippery my house was to try to run out the kitchen when you get knocked down every time you try to run.
Before the grease?
He poured grease on me first. I don't know what part of first is not registering.
I don't know what part of first doesn't register to you. You said that originally.
He poured grease on me first. Okay?
First thing he did was
first when he came in the house, he knocked me out. Okay?
I recognize that this is a very tense situation, but please, if you could refrain from yelling, refrain from using profanity unless you're stating what the defendant said, and please refrain from asking Mr. Nasser questions.
Okay.
And just try to answer his questions and we can get through this a lot quicker.
Thank you, Judge. May I proceed? Okay, so your testimony now is the first thing that he did when he came in is threw grease on you, is that correct?
No, he came in the house yelling at me, then he knocked me to the floor, then he poured the grease on me,
Okay.
then he knocked me out with the pot several times.
Okay, was there
So my
any,
floor was slippery with grease. So yes, I tried to run out the house. Yes, I tried to leave. Yes, I tried to get away from him.
are you done? Is there anything more you want to add?
Go ahead.
No, I'm saying, is there anything else?
No, I'm just telling you, every time I tried to attempt, I was knocked out.
Was there any attempt made to leave before the grease was on the floor?
What do you mean?
Was there any attempt to leave your home before the grease was on the floor?
When he started yelling, yes.
Okay, you tried to leave?
I tried to leave every time.
Okay, and how did you try to leave?
I don't know if I can overpower a man, but I tried to run out my front door.
Okay, you tried to run out your front door and he stopped you?
Yes, he knocked me out.
So you were running towards the door and he knocked you out?
He knocked me out.
As you were running towards the door?
I couldn't even try to get to the door.
Okay, so it's fair to say you didn't try to leave then, right?
I tried several times.
Okay, let me ask you this, did you open the window and call for help?
How could I?
How could you?
Yeah.
Okay, you're in the
Looking
kitchen.
on the floor out your head.
You're in
How
the
could
kitchen. You're in the kitchen at some
When you
point.
trying to get away and somebody yelling, sit the fuck down?
Okay, you're in the kitchen at some point, right?
I was in the kitchen the whole time. The
Okay,
kitchen is
are there
here.
windows in the kitchen?
Yes, it is.
Okay, let me ask you this, you testified that, that the neighbor was looking around the property,
My
right?
blinds is always open.
I'm sorry?
My blinds are open, they're always open.
I'm sorry, I couldn't hear you.
My blinds are always open. I'm the type of person that open my blinds up in the morning, every morning.
Okay, so your blinds are open, right?
Open, always open.
Okay, so, and you saw your neighbor?
Yes, we both did.
Okay, and did the neighbor see you?
No.
Okay, who's this neighbor?
I forgot his name. He said a couple blocks down.
Couple of blocks down?
I'm sorry, a couple houses down, I'm sorry.
White guy, black guy?
Black.
And you don't know his name?
I forgot his name.
Did you provide that information to the police?
I don't remember.
Don't remember, okay. Young, old,
He's an older guy.
and he
My
lives.
neighbor didn't see the incident no way. All he saw was his car outside. He was looking around the car because he heard me screaming and yelling.
Okay, let me ask you this, where does he live in proximity to you? To the
On
left,
the
to the
same
right?
side as me.
I'm sorry, please, can you finish, wait until it finishes the question before you answer?
Okay.
Thank you.
Thank you, please repeat your question.
Sure, does he live, when you're, this is a single family home, right?
Yes,
So when you, through the front, does he live to the right or the left?
to the right.
How many houses down, if you know?
Like, two.
2 houses down, okay. Is your testimony that at some point in time, Mr. Woodward left your home, correct?
After I told him that the neighbor was a cop,
Okay, so you told him that,
yeah, I lied to him.
okay, and Mr. Woodward left, right?
Yeah, he said he was coming back to get me.
Okay, but he didn't come back, right?
I have to in my car, I don't know what he did.
Okay, I'm saying he never came back to your home.
I don't know what he did.
You never saw him at your home again, did you?
I don't know what he did. I left my home when he left.
So it's fair to say you didn't see him at your house after that, right?
After?
Are you gonna answer, Judge, I'm gonna ask this court director to answer the question. It's a simple question. Did you see him at your house after that?
You
I'm not
asked me
asking her to
if I was in
Let me
your house,
finish,
right?
ma'am. I'm not asking her to speculate as to what he may or may not have done. I'm directing this court to answer a simple question. Did you see him at the house after the incident? Yes or no?
I left my house after the incident.
Okay. And you testified that at this point, you didn't drive to the hospital, you drove to your mom's house?
And then to the police station, to the
Okay,
hospital.
answer the question, yes or no, you went first to your mom's, right?
Yes,
Okay, how far is your mom from your house?
around the corner.
Around the corner?
Yeah, at the time she stayed on Frida.
Okay, so around the corner means a block, 2 blocks?
Hubble and Curtis, she stayed probably like 4 blocks off of Curtis.
Okay, and how long did you stay at your mom's house?
She wasn't there.
Okay, so you weren't actually able to see your mom?
I am absolutely on the same page with you, Mr. Bloomers. What is the relevance to this line
To
of
the
question?
time of arriving to the actual hospital to receive his treatment, where she went? Okay, so.
Ask her.
Okay, I was getting to that, Judge, thank you. So, since your mother wasn't there, then you went to the police station or the hospital first?
To the police station or the hospital, either or.
Okay, no further questions, thanks.
Any redirect?
None from the people, Judge.
Thank you, Ms. Harris. You may exit the courtroom.
Thank you.
Are there any further witnesses for the prosecution?
No further witness from the people, Judge.
Is there a motion?
Your Honor, people move to bind over on all charges.
I'm assuming, Mr. Defense, you didn't have any?
No witnesses, no.
Okay, I'm sorry, your motion again?
People move to bind over on all charges.
Your Honor, I would object to the bind over without further argument. This court has had an opportunity to listen to the testimony of Ms. Harris. Undeniably, this is an emotional situation for Ms. Harris. However, Judge, the preliminary examination is a stage where credibility must be weighed, as although this court certainly has empathy for all individuals that are present within this court, including that of Ms. Harris. The logical reasoning and the mindset of some of these questions and the explosiveness of this individual on this stand, I think, is reflective of how someone would respond under stimuli. And mine are simple questions. Mine are not those posed by an individual involved with a romantic situation or someone who shares a child. So my position is, undeniably, I understand the people's position. I understand that this is a probable cause standard. However, I believe that there's clearly questions of credibility and emotion that are being played here. And again, I would object to the bind over without further argument.
Your Honor, I think that the witness gave consistent testimony both on direct and cross. Certainly, things got emotional and heated on cross-examination, but I don't think that her testimony has changed in any substantial way. And the court's also seen evidence of the serious injury inflicted by the cop for the witness's testimony. So people who I know.
Yeah, so, yes, the witness did get emotional. But the allegations here are real serious. And particularly when you throw in a domestic situation, in this instance, a prior relationship in which the defendant is the father of her child, given what not only was alleged to have occurred on the date in question, but also what, pursuant to your line of questioning, we found out that perhaps there's a whole history here of abuse. Yeah, it does have a tendency to evoke emotion. She's testifying as someone who's on the receiving end of this. So it may be a different perspective from someone who's reading the material and looking at it in a calm fashion. So I understand you're saying you're objecting with our argument, but if you're asking the court to deem that the complaining witness, by way of her emotional response to the questions, is somehow not credible with the testimony that she provided here today, the court respectfully disagrees. And the prosecution certainly has met their burden to establish by a probable cause standard that crimes were committed in the city of Detroit, County of Wayne, and that you probably committed those crimes. That burden has really easily been met here. There is a question of fact that I'm certain your attorney will hold the prosecution to that much higher standard that is required across the street. But as for now, the matter is bound over to the circuit court for further proceedings. The misdemeanor is going to travel along for the efficient administration of justice. And then let me also add, I was looking at the bond. I'm interested to hear if the prosecutor is satisfied with the bond, because after this testimony that has come out, I'm not so certain that that bond, that personal bond with no GPS tether was appropriate.
Well, Judge,
let me just first say that the AOI date is going to be July 30th at 9 a.m.
Yeah, if I can respond to that. I mean, if I may.
Actually, I was asking the prosecutor because maybe they don't have an issue.
I guess I would ask the judge if I could have just a minute to double check with my witness on it.
I would like to know if there's been any issues since he's been placed on bond.
Mr. Ruby, are you on, Baruchko?
What is it?
Are you on Baruchko?
No, that's, Leslie's case.
I wonder if he's still on. Because the attorney is on Zoom. I saw him up there. There he is.
Hudson and Ayers are dismissed.
Oh, okay. Can we call those, Judge?
Yes.
Wait. Hudson and Ayers. Can you get Ms. Barnwell?
Yeah.
And, Mr. Brown?
Yes.
Mr. Schaaf, what did you want to do on Barushko? This is the clerk.
Yes, we were just either adjourning it or setting for exam for discovery. I spoke with the prosecutor. He was fine.
What prosecutor? You spoke with Mr. Slusky. Do you want to set it for an in-person exam? We're in December. Or if you want a probable cause, that's up to you. But we
I
gotta
think
do
a probable cause is fine, you know, if that's okay with the court.
August 6th, does August 6th work for you?
Yeah, that's great.
Okay, you're all set then.
Hey, thank you very much. I appreciate it.
Okay.
Bye-bye.
Do I have the parties on? I'll get my dates all mixed up here. Ms. Farnwell, who do you have?
Ayers,
Sorry. Calling parties on Ayers, case number 2057867. The people of the state of Michigan versus Dantes Antoine Ayers. The defendant is charged with count 1, police officer assaulting, resisting, obstructing, habitual offender, court defense notice. This is scheduled for preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Fufi, P82800 on behalf of the people.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Dantes Ayers, who is present.
And please state your name.
That's it.
Thank you. What's your pleasure?
Your Honor, at this time, the people are not ready to proceed. Police officers Alatia and Officer Ravinsky have been subpoenaed and notified to show up to court today and have not done so.
Is
Your
there a
Honor, we
motion?
respectfully move to dismiss.
Matter is dismissed without prejudice. This matter was set for what time?
10:30 a.m.
Thank you. It is currently 11:51 in the morning. I am going to grant that motion to dismiss. Keep in mind, sir, that it is dismissed without prejudice, which means that it is possible that the prosecution can reissue on this matter. If you have questions about what that means, or the parameters of that, please make sure you speak with Ms. Barnwell, who will certainly explain it to you in greater detail. Do you have on a GPS tether that I need to remove, sir?
No, ma'am.
Okay. Ms. Barnwell, I just need your signature as the moving party on this order of dismissal.
You can wait in the hallway, sir. Calling parties on Hudson, case number 2056710. The people of the state of Michigan versus Alexander Hudson. The defendant is charged with count 1, operating while intoxicated, third offense notice felony. Count 2, operating license suspended, revoked, denied, habitual offender. Second offense notice. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Fufi on behalf of the people.
Hey, good morning, Your Honor. Brian Brown, P80560, appearing on behalf of Mr. Alexander Hudson, who's present. Mr. Hudson, please state your name for the record.
Alexander Hudson.
Thank you. What's your pleasure here today?
Your Honor, at this time, the people are not ready to proceed. Police officer Peoples was subpoenaed and notified to show up to court today and has not done so.
Is there a motion?
Yes, Your Honor, we have motion for dismissal of the date time today. Preliminary examination was scheduled for 10 o'clock, and we were ready to proceed.
Okay, with those representations that have been made, I am going to, Tammy, on that last one, can you add the date? I didn't put the date in there. With the representations that have been made, I am going to grant defense counsel's motion to dismiss this matter. Matter is dismissed without prejudice. Mr. Brown, I just need your signature on this form as the moving party for the dismissal. And do you have on a GPS tether, Mr. Hudson?
No, Your Honor.
Okay. You're all set then. You can have a seat in the hallway.
Thank you.
Paperwork, and Mr. Brown, I just need your signature.
Thank you, Your Honor.
Thank you.
Who did you say? hearings on McMeekin. Case number 21-55532, the people of the state of Michigan versus Justin McMeekin. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, domestic violence. This matter is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, I'm Jeff Perlman on behalf of Justin McMeekin, who's present.
Can you please state your name?
Justin McMeekin.
Thank you. What's your pleasure?
Your Honor, at this time, the complaining witness in this matter, Annalicia McMeekin is not present in the courthouse. She was subpoenaed to be here for an 11:30 a.m. preliminary exam. Without her presence participation, the people are unable to go forward at this time.
Is there a motion?
Yes, Your Honor, we're asking the court to dismiss this matter.
Matter is going to be dismissed without prejudice, as this matter was set for an exam at what time?
11:30, Judge.
11:30. It's currently 11:55. And the prosecution is unable to proceed. I am going to grant that motion to dismiss without prejudice. Sir, please understand that what that means is that the prosecution, that trailer language after the word dismissal, means it is possible that the prosecution can reissue. If you have questions about that, please make sure that you speak with your attorney. And Mr. McMeekin, do you have on the GPS tether?
No, I don't.
Okay, I just need your signature, counsel, on this order of dismissal as the moving party, and we're all set.
Thank you, Your Honor.
Thank you. Mr. Bloomers, or can we go back on the record with Woodward? This is a recall of People versus Dante Woodward, 1906089 Appearances.
Jacob Bloomers on behalf of the people.
And good morning once again, Your Honor, and to your staff, Mohammed Nasser, P74485, here on behalf of Dante Woodward. Mr. Woodward, identify yourself to the court.
Okay, Mr. Prosecutor, you asked to pause to speak with the complaining witness.
Yes, and I did have room to speak with her, and she stated that, she does fear for her life from Mr. Harris, from Mr. Woodward. She stated that he actually did contact her back in the fall and winter after this case had come back into the system. Just a little background, this is a 2019 case. The people's information dating back to 2019, both her mailing address and phone number were out of date. So at the time, I didn't have any contact with her, so I really had no way to talk to her about whether there had been contact back then. This is when she states, that he threatened to kill her. She told me that this is when that occurred, was back after this case had started up in the system, that he had reached out to her and made threats to her. And she does feel that she is in danger from contact from him, particularly now that this exam has been held and the case is going forward. And as far as the people are concerned, having heard the testimony in this case and her concerns, I do believe that a GPS tether should be ordered in this case in order to protect the safety of the witness.
Is she still here?
She is.
Can you bring her in, please?
Yes.
Officer, did Mr. Chambers arrive yet? Mr. Chambers?
That was a few minutes ago.
Okay. My question is, and you're still under oath, Ms. Harris. Mr. Prosecutor is making some verbal representations on the record, and I'm just a little unclear, so I'm asking, has there been any contact? When was he arraigned? Re-arraigned? Was that December or?
Sorry, Judge, the earliest date I have is the PCC on the 21st, so I'd have to look. Do you have the arraignment date?
Oh, here it is. Hold on. October 26th. Arraignment was held at Chortea. So this is my question, Mr. Bloomers. Has there been any contact from the defendant since that date of October 26, 2020?
So Ms. Harris, as the judge said, you are still under oath. After that October date.
Can I look at my phone and look at the thing? Because know he did contact me sometime in November and December.
If you could look just for confirmation.
Okay. The last time he contacted me was sometime in November, December, I believe it was, I wanna say 2019 or January 2020 as well. But that's-
Okay, so since October of 20 of this year, October 26th of 2020, there has been no contact.
No,
And Mr. Bloomers, what you were referring to was from the date of the offense in the 2019 range.
That is what it sounds like. I misunderstood the November, December contacts to be of 2020. not
Okay.
2019.
the last time was 2020 in January. That
Yes,
was it.
before
So
that.
as it stands right now, the defendant's bond is a $20,000 personal bond, no contact with the victim directly or indirectly. It sounds like there's been no violation in the time frame between the time of the arraignment on October 26, I believe, 2020, and today's date. Are you satisfied with the bond as it is?
Your Honor, as I stated before, I would still, based on the testimony and my speaking with, well, let me just ask Ms. Harris, are you fearful at all that the defendant may try to contact you?
Yes, I just don't want him to contact me or say anything to me.
Okay.
Personally contacting you or by way of phone?
No contact, not even with our child. Cause it causes problems with me and him.
And has there been contact
No,
since?
cause I cut his family off and when they see the baby.
I'm sorry, please speak up.
I had stopped letting my child see his family as well.
Okay.
It's better that way.
So seeing as though there has been this disconnect and there has been no violation of the no contact provision, I ask again, Mr. Bloomers, what is your posture as it relates to this?
Well, Your Honor, I mean, based on what I'm getting now, I guess the people are satisfied with bond as current.
Okay, so, I mean, you certainly can, respond, but I don't think it's kind of moot now?
I don't need to respond.
Okay, thank you. So you understand, sir, that there is a no contact provision. I personally think the bond was set really low, and there wasn't a whole lot of safeguards that were put into place. However, with the representations that have been made by the prosecution and that there's been no violations that have occurred between the date that you were placed on, that you were arraigned, October 26, 2020, I'm going to assume that you understand the seriousness here. And the reason why there's an elevated level of concern is because when there's a domestic situation, even if it's not a current situation, there is a natural tendency to want to reach out either in a pleasant way or an unpleasant way. And you are not permitted to do that. It is not allowable. And the consequence would be that your bond would be revoked. And there's no caveat to it, meaning there's no back way around it. For instance, even if the complaining witness came to your doorstep, you still can't engage with her. Do you understand that? Now, she shouldn't do that, but there's no bond on her. The concern that you should have is your bond, which affects your freedom. And many times people get tripped up and get picked up because they think that, well, I can certainly engage if it's talking about something pleasant, or if I'm asking questions about family, or if they come to me, I can let them in. No, you can't. While this case is pending, unless there's some amendment to your bond conditions, you are not permitted to engage. So please continue to do as apparently, according to prosecution, you have been abiding by it and there have been no violations. It's really important. You'll find yourself in a far different situation if you decide to teeter outside of those conditions. You also can't have someone else. Some people think that's a way to get around it. You can't have someone else reach out on your behalf. Do you understand that? Okay. With that being said, also I ask you not to do anything that would gaslight the situation. I would ask you not to seek out the defendant while this case is pending, because it's just not going to be a healthy situation. And that's usually what I ask the prosecutors to do, is to make sure that they encourage their witnesses to also maintain a certain level of integrity about them throughout this process. Is there anything further?
Nothing from people, Judge.
Thank you.
Thank you, Judge.
You're welcome.
Your Honor, there is on Mr. Chambers,
Pardon?
and Mr. McDowell said, quote, "I am ready to proceed."
Okay.
Did you say that Mr. Chambers is not here?
I don't know, is Mr. Kearney up there? For some reason, there was a motion on the docket for a Norris. Look at Mr. Malafide, so patient.
Mr. Blumers,
Yes.
did you speak to Mr. Malafide regarding this motion?
He actually, yeah, I know it's been a minute, but he actually did send it to me previously. I don't have any issue with it.
Okay, do we need to?
Can we call it?
I don't think we even need to go on the
I
record.
can just sign it. Is there a proposed order there?
Fantastic.
Thank you.
I'm sorry,
Thank
Tim.
No, it's okay.
I will, email it to you as soon as I get the signature, okay?
Perfect. Thank you, Mr. Bloomers. Appreciate it.
Have a good one.
Any word on Mr. Chambers?
Not for me.
Did we get a call from?
I haven't heard from him. Let me see if he sent me a text or something. No.
And then I know Mr. Kearney is around. I saw him.
Yes, he was.
That's just a motion though, and I don't think.
But is that something we can do real quick? I mean, we're running out of
Kearney's
time.
thing I think will be quick. I just gotta find him.
It's almost 12:30, so.
Yeah.
Wait, Timmy, so, this was a case that was.
It was already bound over. It was already bound
It was
over.
bound over. Then why is it a return for property?
Ask Mr.
Yeah, I think so.
Here's the motion, the actual motion. But, here's all I like to, since, nobody else seems to be concerned that we're almost finished with the morning docket. And we're gonna have to listen to. It's not like we've been in here playing games all day, though. Ms. Rapuki, do you have a cell number or something for Ms. Yaldo?
Miss Young?
Yaldo,
Yaldo.
Mallory Yaldo. I kicked that over to Tuesday. When I look her name up, there's no number in the system for her.
I don't.
And I don't have her. That was on the,
Oh, it was dismissed. That's what.
the other one that you asked me about.
Oh, the Richardson one?
Yeah, no, the Richards one, the
Oh,
Richards
it's
one,
already set for exam.
it already had an exam date. It was back today regarding the
The
test.
Savage one.
Yeah, Savage.
I'll email her.
Yeah, just tell her we kicked it over to Tuesday.
Okay.
I mean, I wonder if he told Arnie he didn't want him here to help him.
Maybe, but that puts us in kind of a pickle because we would still need him to.
To say that.
To say
Yeah,
that.
we
Well,
can't.
I know, yeah, I'm sure.
Did you try to call Mr. Chambers?
I haven't actually had time, but I'll see if I can do it. I'll see you text.
Mr. Chambers, Your Honor.
You said he's there?
He is not there, no. He is nowhere to be found. Up and down the hall, I scream, Mr. Chambers, Counselor Chambers.
All right, let me call him.
He goes, I had no contact with him. I'm not supposed to. I'm like, oh, yeah. Yeah, I'm right.
Did he
I'm gonna
say
stand
maybe
real
a
close to
family
him.
emergency
Yeah.
or something? 2158983, People of the State of Michigan versus Leroy Joseph Norris. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, assault with a dangerous weapon, felonious assault. Count 3, domestic violence, second offense notice. Count 4, malicious destruction of building, $1,000 or more, but less than $20,000. Sexual offender, third offense notice, commission of a felony with a motor vehicle advisory. This is scheduled for a motion hearing.
Thank you. Appearances, please.
Jacob Blumers on behalf of the people.
Police Attorney from the Neighborhood Defender Service of Detroit, P83960, on behalf of Mr. Norris. I request permission to waive his presence for the purpose of this hearing.
So ordered.
Judge, Mr. Bloomers and I had an opportunity to talk in the hallway. His complaint is not going to be available for the currently set July 22nd exam date. And as such, Mr. Bloomers would not oppose converting Mr. Norris's bond to a personal bond. He's currently held on a $1,000 bond. And I will not object to an adjournment of the case to more than 90 days out.
Okay, so he's in custody, but the exam, I have it listed here as July 21st, but maybe that's an error. And Mr. Bloomers, you, under the understanding that the exam would need to be kicked out because of your witness problem, right?
Yes.
You're now saying you have no problem with reducing the bond?
To a personal, with the GPS tether, just to give the court a little background, I spoke with the complaining witness this morning. As a result of the accident at the heart of this case, the crash at the heart of this case, she suffered a shattered pelvis. She was in the hospital. She's out of the hospital now, but is basically immobile. She said, I told her the exam date. She said there's no way I could get down to the courthouse for that, to be here in person. And she also said, as far as the bond goes, we had a chance to talk about that she didn't have a problem, and she volunteered this, I didn't even ask, that she didn't have a problem with him being released from jail so long as he was on GPS tether. And so what I proposed to Mr. Kearney was that I would stipulate to that personal bond with GPS tether if we could adjourn the matter, past 90 days out from today.
Okay, so let's set the date first. You said past 90 days out, what would that put us in October?
Just any day.
I don't know, is that?
Just do October 13th, does that work?
Yeah.
Okay, new exam date is going to be October 13th at 10 a.m. And I'm preparing the bond amendment form. The bond currently is $10,000 cash or surety with a 10% provision. I'm going to amend it to $10,000 personal bond with GPS tether, plus no contact with the complaining witness. And I need your signature, Mr. Kearney, on this motion to reduce bond. I'm gonna hand it for you.
Yep. Oh. I thought you were over there.
Sorry, I thought you were doing work. I didn't wanna-
What is it?
Did you happen to pick up a laptop charger in the courtroom?
I didn't, I don't know if the officer found one.
Did you let him know? Did you let Mr. McDowell know, officer?
I did, Your Honor. He said he'll be back here at 1:30. And code, I don't need no counsel. And I advised him that it is not his choice.
Oh, I'm gonna show you, that's Army, he said 7 minutes.
right at the dreaded 12:30 mark.
We'll let him know, we
I
just
say
told
1:30.
me, Mr. McDowell, 1:30.
What? Oh. I'm gonna do electrical stuff. Don't ask me that today.
Later. Everyone have a nice weekend.
You too.
Blaze, I'll email a copy of this to you.
Thank you.
Okay, everybody enjoy your lunch.
You too.
calling parties on. Calling case number 2158.
I know, it's not, sorry, I'm clicking on it, it's not letting me leave.
Five eight seven six one.
digital evidence, what we call digital evidence, which would be, in this particular case, 4 body cams that I've received. There very well could be a lot more body cams that potentially could be out there, from my understanding of this. But I would let Mr. McDowell address that, or what his take is on that.
Well, I have 2 issues as well that pertain to the issue that the prosecution brought up. I feel that the discovery that I received was altered by 2 ways. One, the magistrate stated on record that there is a evidence that exists where the victim alleged that she do not wish to prosecute, however, she would like the defendant to receive help. That is nowhere in the discovery. Secondly, Mr. Chambers advised me that he received video as well as 911 calls. It's not even hinted at nowhere in the discovery the existence of this at all. Thirdly, it was a statement that was made to a officer, a lead investigator, Eric Scott. He's not even listed on the prosecutor witness list. So I feel that I had a probable cause hearing on June 23rd with Mr. Ken Wiggins, I believe his name was, where he even stated that he did not receive a discovery at that time. The prosecutor gave him discovery as well as gave me one. Through that time, I thought it was, I know I don't know the procedure in the asking for it, but I was under the assumption that law prescribes that the prosecutor turn over all evidence which they use to prosecute me, so I could defend myself against those allegations. Secondly, I wanted to move forward a dismissal today on the grounds that court abuses discretion where it adjourned my preliminary examination without good cause. It is my assertion that good cause is not going to lunch when a Wayne County resident has asserted and showed up late to a hearing where she asserted being held hostage by a disillusional boyfriend in her residency. Those type of allegations, as you have made known, is very, very serious. And she could have been feared, or she could have been unwilling to even continue with a lie. Whatever the case may be, the court didn't feel the need to preserve that testimony and put it on record.
Okay, so let me interject. As it relates to the second prong of your motion, that is denied unequivocally, because the court did find good cause and would find good cause again. I don't know. I'm not sure what you're seeing from your angle, but we only have so much time in a day. We actually have an in custody that we're getting ready to pick up with right now. This isn't scheduled for right now, but it bumped over from the morning. And non-custodial matters, you may not want to hear this, but they don't take priority over custodial matters. And the court is mandated. Have you heard of a thing called the union?
No, ma'am.
Oh, yeah, there's a thing called the union that protects individuals that are employed and they are members of the union. And one of the things that it protects is that the individuals that work have a right to go get some sustenance and go to the bathroom, get a drink of water. Now, that's an interesting topic if you want to dive into that. This isn't the proper venue about the union and how it protects their employees, the court officers, the reporter, the clerk. Yeah, so I would work through lunch. In fact, I have before, and it's a problem. All of the felony judges have tried. We've tried. And it's a problem. And it's frowned upon, as you can imagine, because these individuals are protected. It's above my pay grade as to how all that works. And I can't say, you know what? Mr. McDowell's here. You don't get your lunch break today. Hold it. If you got to go to the bathroom, too bad. I don't have that capability to do that. So yes, the record should reflect again that I found good cause and would still find good cause to adjourn and a non-custodial examination or even a custodial examination where we have run out of time and we must break for lunch, to obtain food, to go get a drink of water and go to the bathroom. Yes, it does rise to the level of good cause from the court's perspective, and that is actually what is mandated by the court system. So that was real easy. On the first prong that has been mentioned, Mr. Bloomers, would you care to respond about the discovery?
Yes, Judge. I did provide all the paper discovery that is in my possession to the defendant in court on the record. I would also provide it to defense. I then provided all the video to defense attorney Mr. Riggins while he was still representing Mr. McDowell. So I was under the impression that that would be turned over once that relationship severed. I have not independently provided it to Mr. McDowell, nor have we had any communication about an email address or somewhere I could send it. I also provided it to Mr. Chambers. As far as the 911 goes, I have requested it. I don't have it yet, but part of the, the reason we're here is because the defendant wanted this exam now. The defendant did not want an adjournment to make sure we got, any other outstanding discovery that might be dug up, which is something I'm happy to do, but we are here today in a hurry because the defendant wanted his exam as soon as possible. So the prosecution furnished all discovery in its possession at this time to defense, to two parties, for all the, well, like I said, I explained who I gave it to and when. And so that's where I'm at right now.
And was that first PCC on June 23rd?
Oh, I'd have to double check, Judge, sorry.
And can we have on record a date in which the prosecutor?
I'm sorry, hold on. Yes, the first PCC was June 23rd. And what I did was quite unheard of. Defendant was quite adamant on the record, and I accommodated beyond what the court could accommodate. I accommodated a non-custodial exam. I said it right away. This alleged incident, May 10th, 2021, and a non-custodial matter for which there was an arraignment June 23rd. That's quicker than some in-custody individuals. So my question to you is, do you want an opportunity to get from Mr. Riggins or Mr. Bloomers personally that digital discovery, or do you want to hold this examination? It's a fork in the road, and this is where we are. The motion to dismiss is denied.
I understand that, ma'am. Yes, I would like the full discovery, and I also would like the date in which prosecutors say he turned the discovery over to Mr. Wiggins, because Mr. Wiggins filed a motion for.
Thank you. He will find that out. We need to select a new date for examination. It will likely be sometime in September or October. That would be soon, because we are really looking at December. The availability is December.
I'm ready to proceed if it's the date is in September, Your Honor.
It's one or the other.
I'm ready to proceed.
Okay, first witness.
Your Honor, the people call Rosalind Smith.
Good afternoon. Could you please state your name for the record and spell your first and then last name?
Rosalind Smith, ROSALIND, Smith, SMITH.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
I swear.
Thank you. If you could make your way over here. If Mr. Bloomers, can you open that gate for her so she can get up easily? There's a few steps you need to mount, and once she's settled in, you may proceed with direct examination. And bring that microphone down towards you, thank you.
Good afternoon, Ms. Smith. Could you please state your full name for the record?
Rosalind Rochelle Smith.
Thank you. And Ms. Smith, on or about the date of June 10th, 2021, were you at the location of 2689 West Grand?
Yes.
And is that in the city of Detroit, County of Wayne?
Yes.
And how do you know that address?
Because I live there.
Okay. Does anyone else live there with you?
Yes.
Who lives there with you?
Stephen McDowell.
Stephen. Oh,
Stephen McDowell.
okay. And do you see Mr. McDowell here in the courtroom today?
Yes.
Could you please point to him and tell the court what he's wearing right now?
He's sitting there. He has on a gray and black sweater.
Let the record show the witness identify the person the defendant.
The record will reflect identification of the defendant.
Okay, so you reside there, or at least on this date, you resided there with Mr. McDowell?
Correct.
And were both of you present there on that day?
Yes.
Okay, so, could you tell me what happened that day that brings you to court here?
He was holding me against my will.
Okay, he was holding you against your will.
Mm-hmm.
How did this start?
Well, it started, he left out in the morning happy about doing something, and he came back, different, came back angry, upset.
Okay.
And he said
So-
that,
Sorry, I'm just gonna stop you. About how long was he gone when he left the house?
a couple of hours.
Okay, and do you recall about what time of day he came home?
No.
Do you remember if it was morning or afternoon or evening?
It probably was afternoon,
Okay.
midday.
Midday? Okay. So he comes home and you said he was different. So what does he do when he comes home?
He asked me that we want him to snap. And I asked him, what are you talking about? He said, do you want me to snap? I said, no. He said, because you guys keep putting roadblocks in front of me every time I try to better myself. And I'm like, I don't know what you're talking about. So I asked him what happened from the time he left till the time he came back. He would never tell me.
Okay. Now, when he said you guys, do you know who he was talking about?
He keeps referring to me as I'm not who I say I am, and that I might be working with either some government agency or police or whatever, that's whoever's out to get him.
Okay. Were you working with any government agency?
No.
Okay. So as he's saying this, what happens next?
He went and got a knife. Well, I didn't know he had it until he pulled it out of his pocket. He told me that.
Sorry, let me just stop you there. What kind of knife was it?
It was a small paring knife.
Like a kitchen paring knife?
Yes.
Okay. Good. So what happens after he takes out the knife?
He said it's all gonna end today.
Okay.
I'm gonna prove to the world that I was right, that you're not who you say you are.
Okay. And so after he says this, what does he do next?
He showed me the knife, and he said that if I was to leave, that he would punch me down, he would stab me and punch me down.
Okay. So now you say he showed you the knife. How was he holding the knife?
He had the handle, and it was like he had put it on his leg because he was sitting down.
Okay.
In my room,
and so at that point, after he says that you can't leave, do you leave? Do you try to leave?
No.
Okay, and why don't you try to leave?
Because at that moment I was frightened that he might do what he said.
And so I just wanted, what were you thinking as this is happening, after he says this and has this knife?
Like, why are we going through this? What happened? That's all I kept asking is what happened when you left until you came back? What happened?
And did you believe you were free to leave at any time?
No.
Okay. So how long does this go on for?
I'm not sure. Maybe a couple hours.
Okay. Did you want to leave?
Yes, I was supposed to leave to take my niece to her graduation rehearsal that day.
Okay. And so you said this went on for a couple hours. What happens after that couple of hours passes?
Well, All I know is after the police was there surrounding the house and everything,
What?
he,
Sorry, I'm gonna just stop you there. Did you call the police?
no,
Do you know how the police got there?
yes,
How did the police? I'll ask you
Objection
different.
leading.
I'm gonna ask you a different question. Were you in communication with anyone other than Mr. McDowell while this was going on?
yes.
Who were you talking to?
I was talking with my mom and my niece, they lived across the street,
Okay.
and I was also texting a crisis center
And when you say you were talking to your mom and your niece, was that in person or on the phone or?
on the phone.
Okay, so they weren't in the house?
No.
No, okay. So the police arrived, and what happens after that?
After we talked on the phone, I told my mom and my niece, I was still texting the crisis center. They wanted me to give them my information so they could contact the police for me. Well, I wouldn't do it because I was afraid that he would get hurt. So I didn't do it at that time.
Okay. Were you eventually able to leave the house?
Yes,
And how did that happen?
he got a phone call and then he jumped up and asked, was this some kind of a joke? So I sat there in my room and I looked while he was in the other room on the phone. So he gets up and he walks out and I stayed in the room because I didn't know where he was going. So I just stayed in my room.
Okay. And after you saw him leave, what did you do after that?
I stayed there for a few minutes and then I came out of the room and I walked slowly to the front of the house to see what happened. And when I seen the door was open, I looked out the window and I seen the police calling my name.
Okay. No more questions, Your Honor.
Cross-examination?
Good afternoon.
Good afternoon.
Ms. Smith, would you lie or attempt to deceive someone for a personal gain for yourself or a loved one?
No.
What is your legal residence?
Objection.
What's the objection?
Well, I would just object to ask her to put this personal information on the record.
I'll rephrase the question. Is your legal residence?
Wait, I'm sorry. Are you asking for her legal residence this very moment? Her current residence at this very moment?
No, ma'am, at the time of the
Well,
incident.
we'll make your question more clear.
I'll rephrase the question. At the time of the incident, was your legal residence 2689 West Grand Street?
On my ID, no.
Isn't your ID a form of your identification?
Yes.
So isn't that attempt to deceive the Secretary of State?
No.
Do you recall talking to an officer about this incident?
Yes.
Was it the day of the incident?
Yes.
Do you recall the name of this officer?
No.
Do you recall what you told this officer?
I told him exactly what I just told the prosecutor.
Did you verbally make this statement to him or did you write it?
I verbally made the statement.
Now, you stated that, the defendant that came home different. Can you define what's different?
He seemed like he was upset and defeated.
And compared to what?
To being happy when he left out.
Okay. You stated you was getting ready for a graduation.
A graduation rehearsal.
Okay, can you define getting ready?
I was gonna start taking my shower before you came in.
Can you describe that process in detail?
I would object to the relevance.
What's the relevance?
The relevant, if I get a little leeway, it would show, the defendant stated that, well, I don't want to give my train of questions away if I have a little, I'll simply rephrase the question. Prior to, well, when Mr. McDowell approached you, were you dressed?
No,
You wasn't dressed?
no, I had on a shirt, a t-shirt.
Where was your phone?
It was in my room.
Where in relation to you?
I don't remember.
Now, can you, repeat again when Mr. McDowell approached you, what happened?
He told me that, do we want to see him snap? And I asked, why are you asking me that? What do you mean? And he said, do you, answer the question, want to see me snap? And I said, no.
And then?
Judge, I'm gonna object to the question eliciting narrative. I don't want us to just repeat the entirety of the direct testimony.
Truth only comes one way, Your Honor.
I didn't hear what you said.
Truth only comes one way. If it's a certain fact, you
Please
say the
proceed,
fact.
please proceed.
Okay.
And then?
And then asked me where was the remote to the TV. And I said I didn't know. So we looked for the remote and we couldn't find it. And that's when you came back into the room with the knife.
So he entered your room with the knife, he didn't go get the knife?
As far as I know, you already had it. I don't know.
As far as you know, you stated he went and got the knife. And I didn't know he had it at first till he pulled it out of his pocket.
Exactly.
So did he go get a knife or did he pull it out of his pocket?
He pulled it out of his pocket.
From sitting down?
Yes.
And where was he sitting down in your room?
On the TV stand. That's in my room.
And how far from the TV stand to where you was standing?
I was by my bedroom. The room is small.
And approximately feet, would you say was 3, 4, 5 feet away?
Maybe 3, maybe 4.
And he was sitting, were you sitting or standing?
I was standing.
And at that point, do you recall where the location of your phone was?
On the side of me.
Okay, now when he pulled out a knife and showed it to you, what was your first instinct? Was it fear or was it he in his delusional state or what?
Both.
Okay. And when he pulled out the knife, what did he utter to you?
That it was going to end today.
Did you take him serious?
Yes.
And then what did you do?
I asked, why do we have to go through this? Why? What's going on? Why?
So you didn't take him serious?
Yes, I took him serious. Because I was scared.
So you say you fear both in the delusional state as well as fear. How did you know the purpose of that knife wasn't to hurt itself?
Objection, speculation.
Objection sustained.
You can answer.
No, oh,
No,
no, you can't. No, she can't.
Were you afraid that he was gonna hurt himself?
No, I was afraid he was gonna hurt me.
So when you're in a situation and you feel afraid someone's gonna hurt you, do you typically comply with their demand? Would you say you would typically
Objection,
comply
speculation.
how that actually happened?
You are asking if, in general, when she ever is in a situation like this, would she ever feel like she would generally comply?
No, I'm sorry, I'll rewrite the question. When you was in this situation where you feel that you were afraid, did you feel your only means was to comply?
Yes.
When did he tell you to make a phone call?
He didn't. I called my mom. I asked, could I call my mom? And he said he didn't care.
Oh, so you asked him, could you call your mom?
Yes.
So he's sitting there with a knife at his side, telling you he tends to harm you for leaving, but he gives you permission to call someone.
Yes.
And while you was placing this call, what was he doing?
Sitting there.
Did he ever get up and leave from that seat right there?
Not while I was on the phone, no.
Again, did he ever get up and leave from that seat right there?
Yes.
At what time did he get up and leave from that seat
I
right
don't
there?
know. I'm not sure.
You said the defendant had been acting delusional. In your, how long would you say that this character was exhibiting your opinion?
For maybe almost a year.
For almost a year.
Almost a year. That I paid attention to.
So within that year, you never had any type of fear or reluctance to check on his mental state?
Yes.
And how did you go about getting off into that?
I begged him numerous times to get help. I asked him to seek therapy. I also pulled up a list of doctors for him to pick, so he wouldn't say I had anything to do with them. And I told him I would go with him if he needed me to.
And did he?
No.
And yet you still stayed somewhere that you say is not your legal residence?
It is my residence. I pay bills there, and I have bills on me right now that's in my name that he does not pay.
But I thought you said that 2689 West Grand Street is not the address listed on your identification.
It's not.
So you're lying somewhere.
I just never changed my address when I moved from across the street.
How long has 2689 West Grand Street not been on your identification card?
4 years.
How long?
4 or 5 years, I'm not sure.
And how long would you say you lived at 2689 West Grand Street?
For the same amount of time.
How long have you known the defendant?
For 12 years.
And within that 12 years, how long have you and the defendant lived at this residence?
Off and on, maybe 2 years, 3 years, because he moved out and moved back several times.
Do you recall the year in which you moved into this residence with the defendant?
We object to relevance.
No, sir, relevance.
Excuse me?
What is the relevance?
Perjury.
Objection sustained.
Did the defendant ever touch you?
Yes.
Did the defendant touch you?
Yes.
At what point did the
Please be
defendant?
more specific. You said, did the defendant ever touch her for as long, in the past 12 years?
No, ma'am. I'll
In a
rephrase.
gentle way?
During the incident in which you just described on the 10th of June, did the defendant ever touch you?
Yes.
At what point?
When he had me walk to the front of the house to see if the police was out there, he made me sit on the floor. And then he grabbed me by my shirt and made me get up and go back to the back of the house.
And when was this?
when he walked me to the front to see was the police there. And he had me sit on the floor by the window while he looked out. And he had me get back up. He yanked me by my shirt to make me get up and walk me back to the back where the rooms were.
Are you making this story up as you go along, ma'am?
No, sir.
Okay, isn't your testimony today that the defendant came home different and that he approached you in your room some few feet away, sitting down with a knife in his pocket for a few hours till he received a phone call when he left out?
Yes.
So when at that time, when he was in your room prior to him receiving a phone call, did he lead you up to what'd you say, the front room?
Yes.
To the front room?
When he wanted to see if the police was out there.
About, from the time he sat down and pulled the knife out of his pocket, was it before or after that?
It was after.
About how long after?
I don't recall.
What made you make a phone call?
Because I feared that he was going to kill me, and I wanted to let my mom know.
So you didn't fear that you reaching out for help will trigger or cause more violence if he didn't tell you to do that?
He said he didn't care.
Is your testimony today that a man that was delusional for over a year was in your room, brandished you a knife, threatened to stab you, that he didn't care if you notified authorities or something?
He said that everybody was going to know that what he said was true. What he said about me was true. And he wanted everybody to know.
So why you didn't call 911 if you didn't care who you was calling?
Because I knew he was having a mental break, and I was fearful that he might get shot by the police. So I didn't call myself.
So you was more fear for him getting shot than fear from him stabbing you?
Both.
Were you in a very abnormal mindset at that time?
No.
You wasn't?
No.
You was clear? So in your opinion, you feel that you was acting rationally?
Yes.
Do you feel that the defendant, based upon a 12-year knowledge of him, was in a abnormal mind state?
Yes.
So would you agree that in this abnormal mindset that you didn't fully believe what he was doing, was taking him seriously?
In that mindset, I was trying to talk to him, to get him to talk to me about what happened when he came in.
That's not the question, ma'am. In the mindset in which you feel he was in, were you taking that mindset seriously?
Yes.
So you saying that was him?
I'm saying he was in a different mindset when he came home from when he left.
Again, in that mindset.
Objection, asked and answered.
Objection sustained.
She didn't answer.
She did answer.
When you made this phone call, what was the first thing you said to the caller who answered the phone?
I told my mom that I was letting her know that Stephen had threatened to kill me.
Threatened to kill you?
Yes.
So do you feel that telling your mom that someone is supposed to kill you, it essentially is still notifying the authorities?
Yes.
So why didn't you simply call the authorities?
Because I was hoping to talk him down before anything escalated even more.
What is your mother's name?
Catherine Smith.
And how old is Mrs. Smith?
She's 75.
So you feel a 75-year-old woman is more apt to deal with a situation in which a disillusioned man have you at knife point than the emergency service?
No.
Again, so why did you choose to call them instead of
Objection
using
has been
fear?
answered.
Objection sustained.
No further questions.
Thank you. Any redirect?
No redirect.
Thank you. Ma'am, you may exit the courtroom.
Thank you.
Thank you. Watch your step as you go out that gate. There's a couple steps down.
Thank you.
Any further witnesses for
No
the
further
prosecution?
people, Judge.
Pardon?
No further witnesses.
Mr. Smith? I'm sorry, Mr. McDowell?
Yes, Your Honor. Police Officer Eric Scott.
Is Officer Scott here?
No, Your Honor.
Officer Scott is not here. Did you subpoena him?
He's on the, he's lead investigator.
Did you subpoena him?
He's on the prosecutor witness list.
Did you subpoena him? The prosecutor has their own strategy as to who they call for witnesses. Did you independently subpoena him?
No, ma'am.
Thank you. Do you have any other witnesses you wish to call?
Yes, ma'am. Police Officer Israel Rodriguez.
Is that officer here?
No, Your Honor.
Did you subpoena that officer to be here?
No, Your Honor, only complaining witness.
Did you subpoena that officer to be here?
1 second. I'll rest, Your Honor.
Motion.
Your Honor, the people move to bind over on all charges.
You reserving
I am
argument?
in reserve argument.
Mr. McDowell?
I would object to binding over for, lack of evidence. It's clear that, the, alleged victim is just creating a story up as she's going along. There's no credibility whatsoever. She testified that, she lived at 2689 West Grand Street. That is not her home, is not her legal residence. She, changed her story, at least 2 different times, adding parts on that's more convenient to her than, taking away parts, that she felt, weren't in line to the prosecutor's, motive. And that'll be all, Your Honor.
Okay, thank you. I've had an opportunity to listen to the testimony that's been provided by the prosecution by way of Ms. Smith. Ms. Smith, I believe, was very succinct in the details that she provided, and she presented herself as a credible witness. There was no inconsistency that was presented itself by way of cross-examination, and the court is satisfied that the prosecution has met their burden here to establish by a probable cause standard. Crimes were committed in the city of Detroit, county of Wayne, and you probably committed those crimes. It's a question of fact to be decided by a fact finder. Count 1, unlawful imprisonment, is going to be bound over to the circuit court for further proceedings, along with count 2, assault with a dangerous weapon, that being a kitchen knife, that the complaining witness referred to as being brandished at the time of the unlawful imprisonment. Count 3 is also going to go along for the efficient administration of justice. It is a misdemeanor, but will travel along with the felonies. The arraignment on information date is going to be July 30th, 2021 at 9 a.m. If there's any additional discovery, digital discovery or otherwise, that perhaps Mr. Riggins did not make its way from Mr. Riggins' hands to Mr. McDowell's hands, if you could first off the record, find out a mode of communication, an email address of some sort for which to forward that digital discovery and get that to him and or Mr. Chambers so that he is in receipt. I believe the only thing outstanding is a potential 911 call.
Excuse me, Your Honor. Where is this, is this held in the same courtroom?
Mr. Chambers is going to let you know where to go for the circuit court matter. It is not in this courtroom. It is in a higher jurisdiction. It will be a completely separate judge. It is now moved on to the circuit court for further proceedings. Okay, people versus, can we get this young man out, please?
People versus Robinson.
And by young man, I mean Robinson. I didn't mean to, I didn't mean to call Mr. McDowell to leave, but it is time for a new case.
Calling case number 2157946. The people of the state of Michigan, can we get Mr. Glenn? People of the state of Michigan versus Tyrese Lloyd Robinson.
I'm sorry, there was noise talking, but what's the name again?
Tyrese Lloyd Robinson. The defendant is charged with count 1, homicide, murder, 2nd degree, count 2, weapons, firearms, possession by felon, count 3, weapons carried concealed, count 4 and 5, weapons, felony, firearm. This matter is scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Good afternoon, Judge Leslie Cooper on behalf of the people, P30857.
Thank you.
Good afternoon, Your Honor. Luke Glenn, on behalf of Mr. Robinson, P38683.
Good afternoon. And could you state your name, sir?
Sorry, lawyer Robinson.
Thank you. Today is the date and time set for continuation of examination. If there was a sequestration, that is going to continue. The Zoom gallery is already clamped down. There's no one on the Zoom gallery other than those associated with this courtroom and this case. If there's anyone watching the live stream on YouTube, if you are a witness or a potential witness, you should stop from watching the live feed to maintain the integrity of this process. Are we prepared to pick up where we left off?
We are, Judge.
Okay, and I did enable the share screening.
Okay. Thank you. Judge, before we get that rolling, I want to make sure, I think we had gone through, I haven't entered the People's Exhibit number 2, which is notification of rights. I think we did that. Mr. Luther, am I right?
I believe we did. I need to cross-reference my notes. What is your take on that, Mr. Glenn?
Yes, exhibit number 2.
I'm sorry, say it.
Yes, exhibit number 2 is admitted.
Thank you, Judge. So we are ready to roll the tape. We are starting at minute 36 of the interrogation.
Thank you so much. And I'm not certain if you figured out, I think it's pretty easy as to how to figure it out. I don't know what it is, but it may require you taking the laptop into another room so we can actually hear. I'm not sure though. Do you know how to do it? Because there are some people that come in here and do it quite easily. Let's see if it works. Yeah, and my notes do reflect that, this is exhibit number 2, correct? Was it?
I'm sorry.
Yeah, I wish I could be more of assistance. I'm not very savvy with the technology. Madam Prosecutor, while he's setting that up, Madam Prosecutor and Mr. Glenn, I thank you for your patience. I thank you for your patience. We had a little bit of a carryover this morning, so I apologize that we did not do it. About that in advance, I apologize.
Thank you, Judge. While we're waiting for that to be set up, Judge, I think we have a stipulation as to the Register of Actions regarding the conviction of Mr. Robinson from 4/5/21. And that would be People's Exhibit 4, or Proposed Exhibit 4, and that is the Register of Actions indicating that he pled guilty and that plea was accepted on 4/5/21.
Mr. Glenn?
No objection for exam purposes only.
Okay, I will admit that as People's Exhibit number 4. And Madam Court Reporter, now that we actually have court reporters in the courtroom, I believe she does have stickers. Do you have stickers?
Yes, I
Okay,
do.
so let's take a moment while we're setting up the video for her to label that. Tammy.
Yeah, may I be allowed to sit on the bench so I can see it?
Absolutely. And Mr. Robinson, I apologize to you as well. I didn't just mean to focus on the attorneys. I apologize that you had to wait for your case to be called. You had a spillover from the morning, and that's why you were sitting there waiting. We're gonna get it done though.
I'm still working on it, Judge.
Okay.
He just needs to sign on it and share and play.
And do you want us to try and call IT down and see if they're in the building?
He said he's gonna play it for about 5 seconds. He can hear it, so he's wondering if
Okay.
it's transferring.
And I'll maybe turn it up a little bit too.
May I say something, Judge?
Yes.
It's been my experience that when I turn the volume, put the volume on mute on my device, that I can still hear them, but I don't know if that's the same
That,
thing.
it didn't work, so I didn't hear anything.
How long is the video?
It's about 36 minutes.
And we will need to stop at 3, no later, we can't go past 3:45, 3:40.
Oh, yeah, we should be well done by the help. Get it run.
Yeah, I wish I could. Tammy, maybe we could just, while they're working on it, see if we can call IT.
They're gonna tell me that they don't do
I know.
anything with Zoom.
Do you have, what does Mr. Mysick use? He uses that TV and he connects his computer to it, right?
Yeah, he's hooked up to the shared screen.
Because we did that before we even got started, we got to that, so. The sound is not, that's not good.
The TV, they use a dongle to connect it to the computer to the TV.
But they can't do that now because it wipes out the live feed.
Oh.
That's why they can't just hook right up to the television.
Oh, but when Mysick would bring the TV up.
Oh, yeah, for sure.
That might be a
It
backup.
should
Still can't. I'm about to try it right now.
Okay.
Sorry, my bad.
Wait, was that you?
That was him.
Oh, okay.
No, that was the tech.
Okay. Yeah, we heard it.
Oh, did you hear it?
Just for a moment. Yeah, we hear it.
Okay, y'all can hear it?
Yes. Oh. That's you we're hearing
No, I
now.
think it was the other officer.
It was him.
Oh. That was a false alarm. I thought we were hearing the video.
Kind of run me through what happened then.
Okay, whenever you, I can hear y'all, just whenever y'all ready for me to play it.
We're ready.
Okay, sorry about that,
Thank
y'all.
That they should voice it.
I didn't either.
I'm not gonna bullshit you, man. I'm just not. So kind of run me through what happened that day. Yeah. Yeah. Which gas station? Okay. Okay.
He's talking. I can't hear him. I'm sure if I turn this up too loud in a second, we're gonna hear it.
Okay. That's fine. What happened though? Okay. And how many times did you shoot? How many times do you think? Well, that's cool. What kind of gun did you have?
We're not picking up.
We're not hearing his response.
Well, but you gotta know what kind of ammo it is, right? The reason I'm asking is I wanna make sure what you're telling me is true, right? I wanna make sure you're not bullshitting me. Do you remember what caliber it was? What caliber was it? A 9? Okay. And, what kind of gun did you have?
I did auditory thing here going.
I know, on the original video, you can hear the responses, so I can have that fixed.
You're on foot? How'd you get up there? Okay, how'd you get up there? Yeah, to where the shooting took place.
Like he's frozen.
Alright. I said it was Normandy and Pure. You keep saying Plymouth. I know what you meant. No, that's cool, dude. I get it. Okay. And meet him. What made you know he was the guy that you were going to buy from? Like, how did that happen? Did you guys just walk in, run? How did
Responses.
how'd you guys meet? Like, how'd that happen?
That made me speak a tape though.
And I'm trying to, turn it up.
I'm gonna try and use another laptop and see if that works.
Okay.
Okay. So you ran into him on the street, that he has weed that he can sell you, and then go ahead and run me through it again?
I apologize.
Okay. Okay. Let me ask, did he get any shots on you? Did he have the gun holding on you? Where's your gun go? Where's your gun? Where'd you go?
Okay, can I have a meeting ID, if possible?
360-233.
Okay.
0000.
Thank you.
You're welcome. Is that DeMarcus?
DeMarcus Elder, yes.
Yes.
Yes, ma'am. Okay, Judge, I'm ready.
Okay.
This clip starts directly at the 36-minute mark.
Okay.
All right.
That we're not getting any sound now. Let me see if I can figure out what's going on.
Okay, you're not getting no sound at all again?
Say again?
I said you guys aren't getting any sound at all again?
No, unfortunately, we're not. Before, we only were hearing from one officer, and now we can't hear anything. In fact, it's still. Maybe that's the problem. Just still.
1 second here, I'm sorry.
It's technology.
Spencer, how you doing?
I'm great, how you doing?
Good. You need a Jolly Rancher?
No, thank you, I'm fine.
You need a Jolly Rancher on?
I'm good, thank you, Your Honor.
Would you like one?
Yes,
He's like, well, can you come closer? Because I've got an array.
It don't matter the color.
Are you sure?
Yeah.
I can't believe you're saying it doesn't matter. Like, now
Here, I'm throwing
I
a
can't
couple.
pick which one.
Throw out a few and I'll take one too.
All right.
What do you look like? You like green?
I'll give a rainbow.
Person?
Thanks for the rainbow. Thank you, Your Honor. You're welcome. I'd rather you first choice.
Thank you. Appreciate it, man.
Oh,
Thank you, Madam Court Reporter.
Oh, my goodness.
I'm trying to cut back. Watching your girly shaker.
I feel like, this morning we didn't really stop at all. I feel like it was just like one big day.
Actually, this whole week.
Yeah. Will you be with us next week, Madam Court Reporter?
Yeah, I'm not sure. I haven't seen the schedule yet.
Well, I hope so. I hope it wasn't pleasant.
It's all in a day's work.
It had to be entertaining.
It's all in a day's work. I've been doing this for 45 years.
Oh, wow.
So I expect anything.
Well, you must get some sort of a plaque or something after all those years.
No, I'm just
Certificate?
satisfied with my sanity.
I think Pete got a certificate. Didn't she?
Oh, she did. From
Yeah,
the
the state
court.
sent.
How long have you worked at the court?
How long have you worked at?
Here, 36.
Altogether, I'd say about 35.
Wow.
Yeah.
I wonder if people have IT in the building, because sometimes they're right there, Johnny on the spot.
I call and ask, but every time I call them, they're like, we don't have anything they need to do the share screen.
But even if we did the TV connecting to the computer, not to this one, but.
Yeah, the one.
So Madam Prosecutor, there's some prosecutors, particularly Mr. Meisick, will go and there's a TV, an actual, that is on a cart in the first floor. And he brings the TV up here, connects the computer
to that
with a dongle, and then plays it on the TV.
Okay, I don't know anything about that.
Neither do you.
I will ask him, because he's from the tech unit, so he knows all.
Oh, I see.
I will ask him.
Yeah, it's down on the first floor in what they call the prosecutor's office.
I don't even know where that is.
Neither do I.
On the
It's under
opposite
the
side,
elevator or
on the
something?
opposite side of the escalators.
Okay, well, let me find out if he knows about that, thank you.
They do a direct link to that court?
Well, but then that knocks out the live feed. And we've got to keep the live feed going unless prosecution and defense, kind of a mandate.
Is it if they hook up in here and they go through shared, then they turn off their mic and their.
Just their mic, right?
Just their mic, and I think that gets rid of that background, that.
Yeah, but then what we had on top of that is we could hear some portions,
Right.
but not all of it.
But, I don't know if that was gonna take.
I don't think with court permission, I'm gonna go downstairs and see if I can find something.
I'm sorry?
I'll go downstairs and see if I can find it.
Okay.
Yeah, that was kind of weird that we could hear the officer, but we couldn't hear.
Nothing.
No, they're not answering. Oh, yeah.
not really locked downstairs and we can't get access to it. So he's explaining that for some reason that the coding on this isn't matching, so it isn't.
So
going
for her, it is a redacted, it's just a clip of where she wanted to start to end it. And the coding on her laptop is different from the tech laptops. So when I put it on her laptop, it was not playing at all. I tried to use the original version, and of course the audio for the person's voice was low. It was too
This is
low
what
for
I
me.
suggest.
I'm sorry?
This is what I suggest. Do you have an MP4 format for me?
Yes, ma'am.
Can certainly get you that.
Could you get it to me like Monday, and then we can return on the 13th, just for, was there any testimony that was needed?
No, I believe the only thing left would be cross-examination of Sergeant Reed, which we could do today, and then play the video on that second day whenever you want.
That, okay, yes.
That's okay.
I think that would be great, because that would allow us to have some speed forward.
Okay.
And then we can return, even though we don't have space, we'll create it because of the priority here. And that would leave us just with a motion, provided defense is not presenting witnesses, a motion and bind over response.
Yes, we should be able to do that within an hour.
And I think we can squeeze that in, certainly. And Tammy, in fact, okay, yes, let's do that. So do you have, you're gonna present cross-examination, officer
Yes.
for cross-examination?
Yes, I'll do that right now.
We'll not get that moved. We get that. It's something was done today.
We do have the availability to transfer the information to your desktop
Yes.
now.
Yeah, but via what?
Or it would be like a hard drive. I have a hard drive with me right now.
Okay, we can try it, but,
Download that.
If not,
let me just say, when that's been tried before, it usually, I just need it on the MP4 format. Like I said, I'm not tech savvy, and I have the guys come down and they say, no, just tell them to give it to you in MP4 format.
okay, so a disk is fine?
The disk is fine, but it has to be MP4 format.
Yep,
And I would suggest we just, as quickly as we can, so we can at least make some headway with regards to the cross-examination.
All right, thank you.
If you don't mind, Mr. Glenn, if we proceed in that manner, so we can.
I don't really have a problem with the procedure, it's just that, my question would be more lengthy after the tape. So right now, I don't really have any effective cross-examination.
I got you.
I wouldn't want to waste time.
Okay, I got you, and that makes sense, and I wouldn't want to put you in a position where you're like, well, wait a second, now that we've seen it in front of everyone, I do have more questions. I'd rather for Mr. Glenn to be organized after he's seen it and then proceed with the cross-examination that is together, as opposed to kind of bifurcated. So, Madam Clerk, can we, what is our afternoon exam on the 13th? I know we've got homicides every afternoon, but just to have an idea, I know you gave me a bunch of dockets before.
It's a two-bagger.
Okay, let's not do it on a two-bagger day. I would say the 12th, but I still have to.
14th is one person, but he has two cases.
Wait, the 14th is someone with two cases?
Yes.
And what's the lead charge?
Assault, domestic violence, vulgar assault.
Are they special prosecutor or Mr. Blowers?
Bruder.
Okay, what about the 15th? Is it just a single defendant?
No, that's Joka and Putris.
Okay, do we have a double bagger on the 16th?
No, that's a Hilton Park, AUM, but that's with the interpreters.
I think that's our best bet.
Yeah.
Are you available to come at 1:30 on the 16th? The only reason why I didn't ask about the 12th was because I still want an opportunity to be able to watch the disc.
I understand.
Even if I got it in the morning, I guess I could watch it during my lunch, but with the way sometimes our dockets slide into one another, I don't wanna inconvenience people and I haven't fully watched the 30 minutes.
Sure, we will make sure that that gets to you Monday, and then we'll be here on the 16th at 1:30.
Mr. Glenn? If not, could you be here on the morning of the 16th and we'll try and punch our way around that?
Yes, I'm here, actually, yes.
That's better than 1:30?
That's better than 1:30.
Okay, so we'll say, July 16th, when she gets off the phone, we'll get a better sense of what time in the morning. I think it's definitely doable since this is,
TH 36.
we know what's remaining.
Yes.
Would you be available in the morning?
I'll make sure that I am.
Okay, I'll make you happy. Okay, no problem, I'll be looking for it. All right, bye.
So Madam Clerk, we jiggled it around a little bit. We're looking at the 16th still, but not at 1:30. So what would be a good time? I'd almost rather do it on the earlier side because we say later and we get behind stuff.
Oh, if we do it early?
If we do like
We
maybe
have a
10?
lot scheduled at 10.
Oh, we have, what about 9?
Let me look real quick. I mean, we can do it at 9:30, because we do have other matters, we have another matter that's in custody at 10.
Okay,
9:30?
so 9:30, could you be here then at that time, Mr. Glenn?
Absolutely.
And that would be first up, that would be
Okay.
first up.
Okay.
July 16th, the record should reflect July 16th at 9:30. The record should also reflect, I don't know if it was made clear, we were talking a little bit off the record, but as the case is off, you never know what's gonna happen with technological issues. It's wonderful to have this technology at our fingertips, but sometimes it doesn't work smoothly. And it is an important aspect that the prosecution and defense want the court to have an opportunity to view this interrogation. So we are going to adjourn for July 16th at 9:30. In the interim, Madam Clerk, Madam Prosecutor has indicated she will be dropping an MP4 disc of the interrogation off on Monday, the 12th.
Yes.
And that will give me ample time between now and that Friday to view it, and then we can get off to a running start to finish this held in part examination. Mr. Robinson, I know this is not, happy news to your ears, but hearing the interrogation is an important aspect of this examination. And unfortunately, as you can see, there's been ample efforts made to get the disc played here today, and we cannot. So we're going to eliminate that as an issue because I'm going to watch it in camera back in my chambers. And when we come back, then we will pick up with your attorney being able to cross-examine the witness that's remaining, and then we'll finish up with our examination. Okay? All right.
Thank you, Joe.
Thank you.